May I please? Sir, this is evidence.
We'll have to wait, I think. Yes, right. As per office note, notice was issued to the respondent number 1 on 20 March 2023. Await service report.
The interim order may be continued.
Interim order to continue till the next month.
May I please, madam. My lord, item number 9. Mr. Talukdar is appearing on the last occasion, my lord. He was not keeping well. He's still not keeping well, my lord. My lord can have it tomorrow. The other matter is same matter, analogous matter, my lord. Tomorrow, if the other one hearing will do, my lord, for both.
I'll release the matter tomorrow. On the prayer made on behalf of Mr.
My lord can put my name, my lord.
Let's say on the prayer made by Mr. Lieutenant.
Tomorrow. Much obliged. Item number 9.
May it please, your lordship.
Yes,
I pray for listing a matter for orders, your lordship.
give a day. Law, what is the hurry?
Because the private respondent enjoying the settlement of the fishery. your
Huh?
lordship. The private respondent enjoying the settlement of the fishery, your lordship. And there being no stay order, he is enjoying the fish fishery, your lordship. We are seeking stay in the petition, your lordship.
Now, we will. Some give a date,
Oblige, your lordship.
sometime.
Oblige.
May please, Lordship. Lordship, with due consent from the addressed Lordship, I beg to mention it was 17 Lordship.
Yes,
Lordship, Mr. K.N. Sodhi, senior advocate, he is leading the case. Today he is out of station, Lordship. So kindly take up it on the day after tomorrow, Lordship.
tomorrow we're going to be very busy. Yeah.
Day after tomorrow, Lordship.
Okay, item 17. Okay.
17.
Not this week, next week. Next week. On the prayer made on behalf of Mr. K. Chaudhary, list the matter on Monday.
My lord, I'm mentioning to matter, my lord, for listing for admission. Any date on April, this is a land compensation matter, my lord. Process of verification is going on, but there is no order in my case, therefore they have not verified my land. Any date, my lord, on for admission. These two matters. Both the matter are same.
May it please, your lordship. Lordship, I pray for listing of a motion matter tomorrow, my lord. My lord, what is the urgency over here? My lord, there is a ban imposed on selling and trading of silk items. My lord, the basic act was that the Central Act makes a specification of certain products, that silk product, where a table has been produced and the specification has been mentioned. My lord, the traders of Assam and the entire district, my lord, they are producing products where the specification is on a different footing, and the GST code applies on that, makes a description of the product which states that these products are to be produced under the hand. My lord, at this point of time, my lord, it is the season of selling of Tegla Chadar. My lord, a ban has been imposed by the state of Assam. My lord, against that order,
Monday.
my lord, tomorrow it would be, my lord, because this is the season. My lord, 5/14, the Bihu season would be starting. My lord, they are all, my lord, affected by this, and the seizure procedure has been, my lord, now being taken up. There are a series of 10 matters, my lord. May I pray, my lord? if that-
We are very busy now.
My lord, I do understand, my lord, but at this point of time, when the businesses, entire Assam has been affected, my lord, I would pray, my lord, to take it up.
Difficult. Till 7th, yes, very hectic. Said,
My lord, only difficulty is that, my lord, on 7th, senior would be out of station, my lord. Can it be tomorrow, my lord? We'll try to satisfy, my lord, on the limited point. My lord.
it is not that. The thing is with the timing.
I do understand, my lord, at this point
Yeah.
of time, it would be inconvenient for my lords.
Very inconvenient.
My lord, I do understand, my lord. But there's no way out, even for us. My lord, can it be on Wednesday, my lord? Yes. If my knee pray. my lord.
Wednesday, especially,
My lord,
there's no
definitely,
chance.
definitely.
There's no
Can it be
chance.
tomorrow? That's why, my lord, I have to pray.
We can try. Okay, tomorrow.
My lord, highly obliged, my lord.
May I please your lordship? If I beg to mention for listing a WPC 841/2023. That's it, matter regarding no confidence. Yes, matter.
Give a date.
Organized.
May I please, your lordship. With due concern of the other side, your lordship, I beg to mention item numbers 26 and 28 of the supplementary list, your lordship.
Yes, what about it?
Due to some personal difficulty, my senior could not come to court today, your lordship. Let the matter be taken up on Wednesday.
On the, on 26, 27. Give a date of, all right, on the prayer for adjournment made on behalf of Mr. Yes,
2628, your lordship, I put numbers.
on the prayer for adjournment made on behalf of Miss,
MS N Mohanto.
huh?
N Mohanto.
N. Mohanta. Learned counsel for the petitioner. N. Mohanta's name is not there.
It's not there, your lordship, but I'm appearing on behalf of Mr. K. Chaudhary.
On behalf of Mr. K. Chaudhary, list the matter. After this.
Wednesday, your lordship.
No chance.
Tomorrow, your lordship, we have some urgency, your lordship.
We are also having an emergency, madam. It's not a one-way traffic.
Then let the matter be called today itself, your lordship.
You said he's not free. The whole day, no,
We have some urgency, your lordship, and let the matter be called today.
this is the matter Monday.
Deeply obliged.
May I please your lordship? Lordship, I beg to mention for listing lordship, matter regarding tender lordship. Kindly any day, please. Sir.
Huh?
After due vacation.
Give a date.
I may be allowed to do this petition.
On the prayer of Mr. S. Islam, learned counsel for the petitioner. The writ petition stands dismissed as withdrawn.
Regarding
Huh?
My lord, there is status code, my lord, recall it. No, lordship.
liberty may be granted. Yes.
Acha. With, just say then, Mr. Then you should have said it in the beginning, Mr. Counsel, when you pray something, then Mr. S. Islam, learned counsel for the petitioner, says that he may be allowed to withdraw the petition with liberty to file afresh. Mr. K. Gogoi appears for the respondent.
Lordship.
On the prayer of Mr. S. Islam, the writ petition dismissed has withdrawn with liberty as prayed for. Status quo order passed earlier stands vacated.
Lordship.
Right, please, Your Lordship. Lordship, in this case, the petitioner is aggrieved by issue of an warrant of arrest against him. Consequence to a Bakijai proceeding, Your Lordship, without giving any notice and without following the procedure, Your Lordship. In this case, the petitioner, he was initially settled with a mining contract for extraction of sand gravel, and it was settled in the year 2014. From 2014 to 2017, Your Lordship, he had undertaken the work, but thereafter in 2017, they gave a portion of his mining area to some other person. Being aggrieved, Your Lordship, this petition has been filed, Your Lordship, and he ultimately had to abandon the mining work, Your Lordship, because of the callous attitude of the respondent authority. And thereafter, Your Lordship, a Bakijai proceeding was initiated, a notice was served upon him, and he gave a reply. Lordship will find that at page number 104, 102, Your Lordship. I'll directly come to Bakijai proceeding because that is what is the issue before Your Lordship.
Yes,
And not at page 104, a notice was issued, Your Lordship. Page 104. Under the Bakijai. And pursuant to the receipt of the notice, Your Lordship, at next page is 105, he has submitted a reply denying that he is not entitled to pay the amount as claimed, and also informing the authority that that a case is pending before this honorable court in respect of this issue, Your Lordship. He is claiming refund of 50 lakhs rupees that is lying with the respondent authority. But without considering all these aspects of the matter, Your Lordship, no hearing was,
what do you file a reply, so?
Lordship,
You file a reply when?
on 22/11/2021. Page 105, Your Lordship.
Recovery of 20 lakhs.
Lordship. The notice is at page 104. Now, as per the Act, Your Lordship, Bengal Tax Recovery Act, once a reply has been filed then there is a requirement of hearing of the matter. The hearing should take place and then your lordship, an order may be passed. But without doing all this, your lordship, ultimately at page number 119, your lordship will find that a warrant of arrest has been issued against this person, your lordship. Page 119.
Yes, Mr. Gogoi.
At this stage, let notice go, your lordship.
Huh?
His period is already over, his small period is already over,
Ah,
and this say I'd like to pray for notice, your lordship. I'll take instruction from you.
what about the warrant of arrest?
That has been issued by your lordship. From DC office, your lordship.
Huh?
From DC office. Very problem, investigation.
And the Bengal Public Recovery Act prescribes the condition under which a warrant of arrest can be issued, your lordship.
But you go and appear before the concerned officer. When is the date fixed?
No date has been fixed, your lordship. They have directly issued this to the officer in charge of the Bardua Police Station, asking him, your lordship, to arrest
But we'll fix a date for you to appear before this office.
before the
To the officer concerned, to the certificate officer.
certificate of.
Yes.
Till that time, your lordship, I may be protected. Will appear and we have already submitted a reply. A hearing must take place, your lordship. And then
Under what provision? Show me the provision.
lordship will kindly take up the Bengal Public Demands Recovery Act 1913. Proceed supply, your lordship. You have one copy, no? Lordship will kindly take up section 5(6). It prescribes how, when a Bakijai proceeding can be initiated, your lordship, and what is the procedure. And especially report to your lordship. To section 7, your lordship. Section 5, that notice has to be issued, and section 7, that a reply has to be given. Once the reply is given,
Wait, one at a time. Which section?
section 7, your lordship.
Where does it say hearing is required?
Lordship,
Where does it say hearing is required?
lordship, I'll just give it.
Notice has been given, you have answered the notice. What is the requirement? That's more than enough.
Section number 9, your lordship. Section 9, may I read, your lordship? The certificate debtor may, within 30 days from the service of the notice required under section 7, but where the notice has not been duly served, then within 30 days from the execution of any process for enforcing the certificate, present to the certificate officer in whose office the certificate is filed, or to certificate who is executing a petition in the prescribed form signed and verified in the person denying his liability in whole or in part. So this is the reply you have filed, and then, your lordship, that certificate.
This is not on the certificate.
Section 9, your lordship, and then section 10 says. I have appear and we have also filed a reply, your lordship, denying the liability, and then section 10, your lordship, it takes up. The certificate officer in whose office the original certificate is filed shall hear the petition, take evidence, and determine whether the certificate debtor is liable. So we have filed reply, but thereafter nothing had taken place, and then we have come to know that this warrant of arrest has been issued, your lordship. And what is the condition for issuing of warrant of arrest? That is provided in section 29.
So where is the certificate issued?
This is at page number 102, your lordship. That is the notice that they have filed under section 4, your lordship. The notice given under section 7, 104.
Page 104. Once a notice is given, your lordship under section 107, the certificate debtor can file a reply under section 9, and at section 10 says that there must be hearing in the petition filed by the certificate debtor.
Where is the certificate signed by the collector?
This is page 104, your lordship.
104.
104, certificate officer, this is the notice. Either the collector or he may depute any officer below him. Notice to certificate debtor, lordship has got it,
Yes.
page 104. Pursuant to this receipt of the notice, your lordship, we have submitted a reply petition. And then section 10 says, if such petition is filed, that should be heard and disposed of. And evidence may be taken to
Okay,
find
right.
out
Heard, Mr.
MHL authority.
M.H. Laskar, learned counsel for the petition who submits that the petitioner submitted his reply dated 22/11/2021 to the notice
Dated
on
21
the certificate dated to the notice dated 21/9/2021 issued by the certificate officer, North Lakhimpur.
as per section 10, your lordship.
But you're supposed to make the reply within 30 days.
No, I have received it subsequently, so there is some delay. After receipt, within 30 days, I have submitted, your lordship.
Mr. M.H. Laskar submits.
On procedure is
Huh?
followed, Lordship. Otherwise, without following the procedure, Lordship, Deputy Commissioner will not issue the warrant of arrest and certificate official. Lordship. Probably this part was already followed, Lordship. A notice and certificate was issued, Lordship. After that is reply, Lordship. After going to the reply, Lordship, the authority issued the warrant of arrest, Lordship. So, Lordship,
No
at
hearing.
this stage, Lordship may direct the petitioner to approach the authority, Lordship. He may appear the authority, Lordship. Authority will decide, Lordship. Because, Lordship, otherwise, without following the procedure, Lordship, authority cannot do anything, Lordship. Here, Lordship, section 7 certificate was issued, Lordship. After that, petitioner is filed a reply in page 105, Lordship. After that, Lordship, that particular notice was issued, the warrant of arrest was issued, Lordship. Probably all procedure is followed, Lordship.
If warrant of arrest is the last resort to be
Lordship.
taken, your lordship, authority will take up.
We'll suspend it and you appear before him. You appear
Lordship,
before the deputy commissioner.
Lordship, Lordship, he will appear before the authority, Lordship.
So what have we said?
Had Mr. M.S. Lawson, learned counsel for the petitioner who submits that the petitioner submitted his reply dated 29/11/2021 to the notice dated 21/9/2021 issued by the certificate officer North Lakhimpur.
Under the Bengal Public Demands Recovery Act, 1943. Full stop. Next para, the petitioner's counsel submits that the reply submitted by the petitioner had been made within 30 days from the date of receipt of the notice. Full stop. He submits that no hearing had taken place on the no hearing or evidence had been recorded by the respondents in compliance with section 9 and 10 of the Bengal Public Demands Recovery Act, 1943, hereinafter referred to as the 1943 Act.
1913, Lordship.
1939.
13.
1939. Hereinafter referred to as 1939. He submits that the petitioner has now been. He submits that that a warrant of arrest dated 9/3/23 has now been issued by the office, by the certificate officer, Deputy Commissioner's Office, North Lakhimpur on 9/3/23 to be executed by the officer in charge, Bandar Deva Outpost Police Station. Outpost/police station. So what is your case? You'll appear before before the certificate officer. Mr. MH Laskar submits that the,
Issue notice in
that,
this matter. In the meantime, I'll
huh?
appear. Lordship may issue notice in the matter. In the meantime, I'll also appear. Because the Pakijai proceeding that they have initiated, completely, your lordship, in violation of the law. And
We
the-
do not know. We do not know.
And warrant of arrest, your lordship, in violation of section 29 of that.
What do we do, Mr. Gogoi?
Let him appear, lordship, the authority will decide, lordship.
What do we do with the case?
Lordship,
Case, writ petition?
lordship may, he is challenging the particular notice. If lordship directed him to appear before the authority, lordship, there is no.
You're challenging with notification,
I have challenged the
104,
Pakijai proceeding.
104. Then you go before that.
Lordship.
Full stop. Next para. Mr. K. Gogoi, CGC, no,
Lordship, government advocate, lordship.
government advocate appears for
Respondent 4, lordship.
correspondent number 4. That's the DC.
Lordship.
Full stop.
Certificate officer I am appearing for. Respondent 4, certificate officer, office of the deputy commissioner, Lakshmipur, lordship.
Appears for the respondent number 4. Full stop. Next one. He submits that as the petitioner has made a challenge to the proceedings made before the certificate officer, comma, the petitioner should approach the certificate officer. Full stop. Should approach the certificate officer with his grievance.
Lordship.
Full stop. Why have you not approached? Where have you approached the certificate officer? Have you approached the certificate officer?
Yes, by filing the reply, I have.
After issuance of 90/2023 warrant of arrest, lordship, he has not approached the authority.
No, since there is a warrant of arrest, your lordship, how can I approach your lordship?
No, so we'll suspend that.
Lordship.
We'll suspend that you approach.
Lordship.
And we'll close the writ petition.
Lordship.
Full stop. On considering the fact that on considering the above facts as submissions made by the counsel for the parties, this court is of the view that the writ petition can be disposed of by at the motion stage itself. Accordingly, the petitioner is given the liberty to approach the respondent number 4 within a period of
30 days.
within a period of why 30 days?
In a period of.
Within a period of 2 weeks.
Lordship.
A period of 2 weeks from today. And to full stop, the warrant of arrest issued by the deputy commissioner's office against the petitioner shall be kept in suspension for the period of 2 weeks.
No, your lordship, then after his appearance, your lordship, it will be revived.
Oh, and then, no, out there you can ask for setting aside.
That is, we
for
have told to
cancelling.
your lordship,
Huh?
but till that time, your lordship, that he should be protected, and your lordship, this
For 2 weeks, we are giving you 2 weeks to approach.
lordship.
He will approach the authority, will consider as per a
Yes,
procedure of
You,
prescribed by the lordship.
2 weeks we are giving you to approach the DC.
We approach, and then we should also consider
Okay.
that should also be,
Uh,
and pass the result.
what have I said?
The warrant of arrest issued by the deputy commissioner office against the petitioner shall be kept.
Shall be kept in shall not be acted upon for a period of 2 weeks.
Till a decision is taken in this regard.
Full stop. It is needless to add that if the petitioner approaches the office of the deputy commissioner within 2 weeks, comma, the prayer of the petitioner for setting aside the warrant of arrest, is it? For recalling
Lordship.
the order of, or the recalling the warrant of arrest shall be considered by the deputy commissioner's office.
By the certificate officer. lordship.
Huh?
By the certificate officer. lordship.
By the certificate, by the respondent number 4.
Oblige, lordship.
By the respondent number 4, and till a decision is taken, the warrant of arrest should not be acted upon.
I am deeply
But it
obliged.
should be within 2 weeks you have got to approach.
I will approach your lordship, until a
Oblige.
decision is taken, your lordship. Oblige, lordship. May I please, the lordship?
Your lordship, here the petitioner is the power of attorney holder, your lordship, on behalf of his own mother and other maternal relatives, your lordship. Now the only grievance of the petitioner is a representation dated 9/6/22, your lordship, 21, your lordship, has been submitted before the respondent number 2 for deletion of names from serial number 1 to 10 of the Jamabandi of the said plot of land, my lord. But till date,
petitioner power of attorney holder.
of his mother and other maternal relatives, your lordship. Luptun Nessa and kindly see annexure A, your lordship.
So what have you done? So you have filed a representation.
Yes, your lordship. We have filed 2 representation, your lordship, but till date.
Representation to whom?
Respondent number 2, your lordship, settlement officer.
Yes, what is to be done, madam?
Lordship petitioner, regarding this representation, we have to obtain instruction, Lordship.
This is a,
And Lordship, this is a.
who is the owner of the land?
Your lordship, petitioner's mother, own mother, Luptun Nessa and
These are disputed questions of fact.
Lordship. And he is also.
your lordship,
And you're a power of attorney holder, you're not even the petitioner.
Makes the power of attorney of the Lordship.
You're not next the power of attorney.
no, your lordship, I have
No, that cannot be. You have it, you keep it like that.
Lordship. And power of attorney holder, how he can claim lordship for entering his name in the Jamabandi, lordship? Power of attorney holder, lordship. Even lordship. And he is seeking deletion of the name of lordship 1 to 10, lordship. It is adjudicated by the authority on the basis of the document, lordship.
Correct.
Lordship.
But your lordship, the names,
And lordship, if such kind of repetition is entertained, lordship, then it will be lordship floodgate, lordship.
1 to 10 are not even the
nothing-
parties.
Nothing will remain to the authority, lordship. Authority
your
will
lordship,
decide.
our only prayer is to consider our representation, my lord.
Representation consideration, lordship, how lordship.
Right. Heard, Mr.
Art Das, your lord.
R. Das, learned counsel for the petitioner who submits that the petitioner is the power of attorney holder of land measuring 13 bighas, 10 khatas, 5 chotak, covered by dark number 9398/9398/9404/9406 of second RS Pata number 1265 in the Jamabandi of the aforesaid land. Pussa. The petitioner's counsel submits that the what is this? Submits that the names of the persons mentioned in serial number 1 to 10 in the Jamabandi have been wrongly inserted. In the Jamabandi. He submits that the names of the 10 persons should be deleted. And in this regard, the petitioner has submitted 2 representations dated 16/6/2021 and 19/7/2021 to the respondent number 2. To the respondent, to the assistant settlement officer, Kachar, Silchar. However, no steps have been taken by the assistant settlement officer, Kachar Silchar, till date. Mr. K. Gogoi appears for
Respondent 2, lordship.
respondent number
2, lordship.
2.
My sister is for 1, lordship.
While Ms. G. Hazarika appears for point number 1. On considering the prayer of the petitioner, this court finds that the petitioner has not submitted any power of attorney. In the writ petition. Further. The 10 persons whose names the petitioner wants deleted from the Jamabandi have not been made parties in the writ petition.
Your lordship, I may be allowed to.
Even lordship, my lord may kindly peruse page 13 lordship.
Yes.
13 lordship. The representation which was pending before the authority, that was also not translated lordship. Next page lordship, vernacular in the Bengali lordship may kindly peruse lordship. Page 14 lordship. Only here lordship incorporate the name of the lordship respondent.
Page 14 is in thing.
Page 14 is the vernacular lordship, but that was translated portion is page 13 lordship.
Okay.
Page 13 also lordship.
Out here, there is all section 145 and whatnot.
Nothing was there. lordship.
Criminal revision.
Even lordship is not translated the whole
To stop, yes,
representation
sir.
also lordship.
On perusing. Page 13, which is apparently a translated version of page 14. It is seen that the petitioner has not translated the entire page 14, which is in the Assamese vernacular. Also. On considering all the above facts, this court does not find any ground to exercise its discretion in the present case, to stop the writ petitions accordingly dismissed.
Your lordship, kindly
Next.
allow us to correct the same and file a fresh, your lordship. I love you.
Yes, lordship, matter into non-payment of contractors bill, lordship. Petitioner completed works as per the work order dated 23/5/2019, lordship.
Mr.
And they go.
Will issue notice, Mr. N.J. Gogoi, learned counsel for the petitioner submits that the petitioner has not been paid his contractual dues amounting to rupees 17,99,949. Issue notice returnable in 4 weeks. Ms. J. Gogoi accepts notice on behalf of
3 and 4 lordship.
3 and 4. While Ms. G. Hazarika accepts notice on behalf of
5 and 8.
response number 5 and 8. What about,
Lordship, I have put 6 and 7 lordship.
huh?
6 and 7 lordship.
Mr. K. Gogoi for 6 and 7. What about 1 and 2?
2 is the final journal, lordship. 1 is the water is a journal.
Finance, maybe 2
Yes.
finance.
2 is finance.
So,
1 is water issue.
so what are resource you're taking or you're,
1, 3 and 4.
Ms. J. Gogoi 1, 3 and 4. Then what about finance?
Finance, the A, only have B go is there, lordship.
B. Gogoi. Mr. B. Gogoi accept notice on their response number 2. List the matter after 4 weeks to enable the respondents counsels to obtain instructions.
Highly obliged.
This is regarding non-payment of higher charges of the vehicle.
Okay, I heard Miss
S. Kakoti.
S. Kakati, learned counsel for the petitioner who submits that the respondents have not paid the hiring charges for vehicles amounting to rupees 44,18,588. Issue notice returnable in 4 weeks. Mr. K. Gogoi accept notice on behalf of all the respondents.
Lordship.
List the matter after 4 weeks to enable him to obtain instructions.
May I say, my lord, item 8 is also similar.
And item
8, my lord.
8,
Yes,
same, huh?
yes, my lord.
Out here hiring rate 63,44,736. And
Lordship, lordship.
everything is same.
Hello.
Right, please, your lordship. But here in this case, our 38 bighas of land, without giving compensation, my lord, government taken and road construction started. This is the simple grievance, my lord.
Is
I
it
have
a
been-
widening of land or is it a new road?
My lord, widening the road, my lord, the existing. road was-
Improvement and widening,
Now it is going to be 2 lakh.
improvement and widening. So, and they've not given you compensation.
No compensation has been paid, my lord. We have filed representation also, my lord.
What is Zirat? What is Zirat? What do you mean by Zirat?
Zirat means, my lord, the tree, etc. is standing on the ground.
Yes, anything to say?
Lordship, alternative remedy is there, lordship.
Huh?
4.17 lordship. 4.17.
My lord, no question of alternative remedy, my lord. It is, Supreme Court has decided, my lord. I am referring a case of 2002.
No, no, if there is an statutory remedy available, then that has to be decided like that. No, this has been, the land is to be acquired under what act?
Lordship, it is a Assam Mala project, Lordship, as per.
My
Huh?
lord, it is to be
That is the
the
notification.
Land Acquisition Act, my lord.
Which 2013,
Requisition, yes, my lord. My 1864 Act also there.
1864?
Yes,
There is a 1894 Land Acquisition Act,
yes, my lord. And
which has been,
Assam
which has been
Acquisition Act also.
repealed by the 2013 Act.
My lord, there is.
I
an
do
act
not
of
know about-
Assam, Requisition of Land Act.
No. Yes, Mr. Gogoi, one thing, this land that the petition is talking about,
Lordship,
this has to be acquired under which act?
This is as per the Assam Mala notification, direct purchase, Lordship. That is the notification, Lord.
Direct purchase is a different thing.
Lordship.
Let us get your affidavit. Under what act it has to be acquired? Okay, right.
Lordship, if petitioner is not satisfied with the provision
Your
of the
Lordship,
Assam Mala
your
Act,
Lordship,
then
page-
the land will be go under
page
the land
34
acquisition
may be
proceeding,
seen.
Lordship.
No, no, let us see
Page-
under
page
what act it
34.
has been acquired.
Your
Where is it?
Lordship, would
Huh?
refer to page 34, my lord.
Yes,
Here clearly said that they want to acquire the land. Act is not mentioned. They invited objection from us, my lord. Page 34.
Lordship, if they are not satisfied with the
they-
Lordship notification
they
issued by the
ask for
government of Assam, Lordship,
Objection, my lord.
for the Assam Mala project, then particular land should
No,
be
my
as
lord,
per the
the
land acquisition
project
act.
may be
Lordship.
something
Mr.
else.
Council, please understand one
Yeah,
question.
Lordship, Lordship,
When you acquire land,
Lordship,
it has to be on the basis of some law.
Lordship.
Please tell me what law has been.
Lordship,
has been
that
applied.
particular land was purchased by the government of Assam, directly purchased from the authority. It is not a acquisition, Lordship. It is
Okay,
a
it was purchased.
purchase, Lordship. If they are not satisfied with the purchase, Lordship, then it will go to the acquisition, Lordship.
Your
As per the
lordship would be
procedure, Lord.
pleased to see.
My lord, may kindly peruse that notification I have already supplied, Lordship.
My lord,
No,
it
no,
is-
no, let me see where is the purchase, where is the
Lordship,
proof of purchase?
Lordship, Lordship.
You are saying it has been purchased, where is the
Lordship,
proof of purchase?
Page 32, Lordship.
32, yes.
In cancellation to the earlier notice dated so and so to the owners and porters occupying tenants of the land, the district level land purchase committee, Lordship, has decided to acquire the land.
Has decided to acquire the land.
Lordship, district level purchase committee, Lordship.
Then
Lordship. The land to be acquired in schedule below and will be done under the direct purchase by way of negotiation
Correct.
for widening the land.
correct.
Direct purchase, Lordship.
It will be done by, where is the purchase?
Lord,
It is like this. You want to say, you say that you want to wear a white t-shirt today. Let me see your white t-shirt, like
Lordship,
that.
Lordship,
What do you mean you,
Lordship.
I agree. That it has been purchased. Show me that proof of
Lord-
purchase.
Lordship, for purchasing, Lordship, we have issued one notification, Lordship, under that notification, it was purchased, Lordship. If Lordship,
No purchase, my
No,
lord.
no, you
No
cannot
purchase.
purchase by way of notification.
Will be purchased.
Please do not make a fool of, trying to make a. fool of-
I am not saying that, Lordship.
You see, can I say that I want to buy your land? I'm issuing a affidavit. Now this land is mine. Can it be done?
That cannot be, Lordship. So,
Then-
Lordship, there is a provision, Lordship.
Mr.
If
Gogoi
he is not
submitted like
satisfied, Lordship,
anything, my lord.
if not satisfied,
Right, heard Mr. M.A. Sheikh, learned counsel for the petitioners, who submits that the petitioners are owners of land measuring 38 bighas. Full stop. He submits
Approximately, my lord.
that though the lands of the petitioners have been used for widening and upgradation of an existing road from a 2-lane road to a 4-lane road, comma, no
From one-
compensation.
One land to two lands.
A 1-lane road to a 2-lane road, comma, no compensation has been given by the respondent. Full stop. He submits that that the state government is bound to acquire the lands of the petitioners and pay compensation. Full stop. As in terms of Article 300A of the Constitution. Full stop. Next para. Issue notice returnable in 4 weeks. Mr. K. Gogoi accept notice on behalf of.
Lordship, I am for respondent number, Lordship. five lordship, deputy commissioner lordship,
Point number five,
five lordship.
while Mr. Huh? R.K. Mushari, you got
Lordship, I am appearing for one.
Mr. B. Chowdhury for one. And Ms. G. Hazarika for two. Two, stop. Mr. K. Gogoi submits that the land of the petitioners has been purchased by the respondents,
Lordship,
and
is a
if
notification-
they are unhappy with the amount, with the consideration fixed for the purchase, comma, they should approach whom? Approach whom?
Yeah, it is PWD হবে না, এটা revenue হবে। Issue হতো।
No, no. They may approach the authorities, full stop. And next para. On perusing the writ petition, comma, there is nothing to show that the land of the petitioners has been purchased through negotiation by the respondents, full stop. Accordingly, Mr. K. Gogoi shall produce documents showing that
Document
the
will be
lands of
produced-
the petitioners have been purchased
document will
by
be
the
produced-
respondents.
Document will be produced by BTC authority lordship.
By, okay, all the respondents shall produce documents
Lordship.
to prove that the lands of the petitioners have been purchased through negotiation.
It is a notification.
And submit their, and produce the sale deeds should be produced on the next day.
Lordship, it is a
List the
notification.
matter, after 4 weeks.
Lordship, it is a
In the meantime, my lord,
notification.
our land may
Lordship,
not be used, my
it
lord.
is a not-
Our land may not be used by them.
Cannot
Lordship,
be
it is a notification, just I am
done. That cannot
clarifying.
be done.
Just I am clarifying, lordship.
It's already a road, cannot be done.
It is a notification before purchase, lordship. They, if they are not.
Mr. Council,
Lordship, my lord,
can you, you say, you see, a purchase means what? What does purchase mean?
purchase-
When you go and purchase fish or you purchase potatoes, what does it mean? You issue notification,
No.
now it's bought.
No,
Or you have to, you say that what is the price? He'll say 10 rupees per
lordship,
kg.
that is
You'll give the
return,
money.
lordship.
That is the purchase.
If they are not satisfied the
Next.
offer price by the government lordship,
No
then-
price has been given, what satisfaction?
Date fixed.
My lord, a date may be fixed, my lord.
Okay, list the matter on, give a date.
Early date, my lord.
Give a early date. Early date. Heard, Mr. N. Ahmed, learned counsel for the petitioner who submits that the contractual dues of the petitioner amounting to 1,90,726 have not been paid by the respondents. Issue notice returnable in 4 weeks. Ms. J. Gogoi accepts notice on behalf of
1 to 4.
respondents number 1 to 4. Who is 5, 6, 7? Union of India,
Union of India lordship, I can represent lordship.
Brahmaputra Board,
Brahmaputra board, I can lordship.
you can.
Lordship, lordship.
And what about Principal Accountant General Hassan? Okay, Mr. K. Gogoi accept notice on behalf of point number 5 and 6. While Mr. A. Hassan,
Name of R.K. Talukdar may be recorded.
while Mr. R.K. Talukdar accept notice on behalf of point number 7. List the matter after 4 weeks to enable the respondents to obtain instructions.
My lord, 13 also same.
Huh?
13 also same.
13. 13 will be 29, 35, 508. Huh? And the list of respondents same.
Same. Same.
Okay.
Lordship, oblige lordship.
Here, I am appearing for respond number 7.
Okay, in Athir it will be A. Hassan
13.
for 7 in 13. In 13 it.
May it pleases you, lordship. My senior Mr. S. C. Khan, he is on legs, your lordship. Can we pass over the matter for time being?
Next.
If you oblige.
The petitioner for transfer of the investigation to the CBI.
Can this bench take up this? I think this, huh? Bench 4 matter. It says residuary writ petitions except police, army action. Yes, who's appearing for the, can this bench take up for transferring the case to the CBI?
Lordships here, the statutory remedies there, lordship. As per the CRPC lordship, has to approach lordship.
No, I'm
It
not
is
on that.
not
I'm not on that, Mr. Counsel. I'm on a different issue.
Lordship.
Can this bench, can this bench deal with the matter regarding transfer of a case to CBI?
It is writ petition under 226 lordship. It is not criminal jurisdiction. So it can.
He wants to transfer a case to the CBI.
Lordship.
There is a bank fraud perpetrated against me lordship. Is has been
Well,
1 year.
because you see, out here, what this bench can deal with, it says here. Writ petition civil relating to settlement by state government, etc. Writ petition relating to land matters. Residuary writ petitions except police/army action. Number 4 is writ petition relating to tax matters. Number 5, LA appeal. So writ petition criminal is not included. Is this a writ
It is
petition
civil.
criminal?
It is writ civil.
Civil?
Civil for direction mandamus.
I don't know. But it does not relate to settlement by state government. It does not relate to land matters.
Earlier lordship I filed similar case 6 months before. It was taken up by bench.
I don't know. It's not that I want to avoid all this. I just want to not to pass orders where I'm not supposed to take up,
Lordship.
some people.
There is no other bench.
Okay, we'll see, yes,
So
anything?
it's fall under residuary.
Your lordship, any other writ petition not placed before any other bank?
And it says except police and police matters.
We don't have anything of CPI. Your lordship, CPI also within police. That definitely.
Okay, anyway, right, heard, Mr.
Yes, report that's.
LG Purkaisa, learned counsel for the petitioner who submits that the Silchar PS case number 960/2022 involving a bank fraud should be transferred to the CBI for investigation. As the state agency has failed to act impartially and fairly. Issue notice,
Lordship, regarding issuance of notice, we have no objection. But lordship, as per the CRPC lordship, 156 lordship, he has to approach the concerned jurisdictional magistrate if he is not satisfied.
156 does not come here.
Let me finish.
No,
If-
one does
if
not
he is-
come here.
If he is not satisfied with the investigation done by the state authority lordship, 156 he has to approach lordship. Sakari Bosu, Honorable Appeals Court already law laid down and it was retired in Sudhir Bhaskara Tambe in 2016 itself lordship. His PR is not satisfaction with the investigation done by the state authority lordship. So he has to approach the concerned jurisdiction magistrate lordship. He will do the needful as per the.
156(3) of the IPC.
CRPC lordship.
CRPC.
CRPC. Yes, sir.
No, 156(3).
Lordship,
It talks of any magistrate
lordship.
It is the
empowered
power of
under
the
section 190 may order such an
To stand for
investigation.
investigation.
No, issue notice returnable in 4 weeks.
156.
Mr. Who appears for Union of India? Ms. B. Sharma appears for respondent number 1. Mr. K. O appears for
Lordship, I am for 2, 3, 4, 6, 7, and 8 lordship.
and who appears for 5?
5.
Mr. M. Haloy appears for point number 5. petitioner takes steps for service of notice upon the respondents number 9 to 11 by a registered post with AD within 2 days. This is the matter after 4 weeks. Yes, madam, what?
Non-payment of contractual bill, my lord.
Okay, right. Heard, Mr.
Take up.
A. Cabra, learned counsel for the petitioner who submits that outstanding dues of rupees 26,65,110 for supply of materials has not been, no, is still pending with the state respondents. Issue notice, huh? Then you're for all the respondents, madam?
I'm for all the respondents, my lord. They have not included, finance as a party, my lord.
Yes, ma'am. Yes,
Finance is not a party in this matter, my lord. I'm for 1, 2 and 3.
just call the Jamadar. Finance not a party, his problem. Miss, so what is the name?
Kotoki.
Okay, accept notice on behalf of all the respondents.
Permission may be granted to add the name of the finance.
Okay, right. On the oral prayer made by Mr. A. Cabra, the Commissioner Secretary to the Government of Assam Finance Department is pleaded as respondent number 4. Registry to make necessary correction to the cost title. Who accepts Mr. B. Gogoi, accept notice on behalf of respondent number B. Gogoi. Oh, Mr. What? Mr. What? B. Gogoi? No. You're not for finance. Are you for finance?
No, that is B Gogoi.
B. Gogoi. Mr. B. Gogoi accepts on behalf of respondent number 4. This is a matter after 4 weeks to enable the respondents counsel to obtain instructions.
May I please, your lordship? Lordship, the petitioner is aggrieved for issuance of a mining permit, lordship, to the private respondent. That imprint order is at page 77. Annexure 12, page 77.
Yes, your mining permit for how many years?
Lordship, it is for, not for years, for some months. It is valid up to February, 10th of February to 16th of June of this year, Lordship.
10 February 23.
23 to 16th of June 2023.
Okay.
Lordship, my grievance is that as per the minor minerals rules 2013, that any kind of such mining permit shall be granted after following the bidding process, Lordship, which was not done in my case. That is my case, Lordship. As per
You have been given the mining permit.
no, Lordship, to the private respondents.
Okay, so you are challenging this. Did you take part in the bidding process yourself?
Lordship,
Did you submit your quotation? There was no bidding. There was no tender.
yes, Lordship, there was no tender.
My lord, there need not be any tender because my lord, there, I'll show my lord. There's a rule 5, my lord, there's an exception carved out in case of government permits. My lord, you'll see kindly page 77 for a moment.
Yes.
77, my lord, will see government department, Panchayat and Rural Development Department.
Yes.
So it's government given to my lord, government permit. My lord.
Oh, it's given to a government
Yes.
entity. According to you, this mining permit has been given to a government entity.
Yes, my lord. There is an
Yes, it's
exception
fine.
carved out. This has been discussed, said there in a judgment, my lord. There's an order of this honorable court. I'm giving it, my lord.
Okay.
Lordship, no, it was given to a private person, Lordship.
Given to a private person.
Yes, Lordship.
So this is to a private person.
Private
it?
person.
Obviously, my lord, department cannot come on its own. It has to employ somebody. For a limited portion of quantity, my lord, government reserves the right. My lord, see that order sheet. Pass in IA number 223 of 22, my lord. Same as statement.
We'll take it to the next one. please.
Paragraph 5, my lord, specifically.
Just a minute.
My lord.
So let us see this order, that's page 77.
My lord.
What is it, for what project or for what work has it been allowed?
My lord, work name is send requisition for schemes under MLA fund, comma, MP, LAD, MP, local area development fund, comma, untied fund. And my lord will see there's a specific quantity, 3405. And my lord, this duration of its permit is from 10 to 2023 to 16/6/2023. My lord, there are two modes of settlement prescribed, my lord, which somebody can extract minor minerals. One is this, my lord, for public construction purposes, my lord, public purposes, this permits can be issued. Otherwise, my lord, there is a mode of settlement by calling tenders, my lord. So this is in a public interest, my lord, that rule is there, my lord, will go to.
But all works are public interest.
No, my lord.
Tell me one work that is not in
That's
public
a
interest.
total different breed. My lord, we'll seek rule 5 for a moment. There's
Huh?
an exception carve out, my lord. Rule 5. I've handed over the rule book.
Because this MLA fund, MP, LAD, all these are basically works given to private bodies here.
And my lord, I have indicated, my lord, that government department is interested, my lord, government, Panchayat and Rural Development.
They have been entrusted to carry out these work.
My lord, yes, my lord. They have applied for permit, my lord. Accordingly, permit is issued to this department, my lord.
Okay.
And my lord will see rule 23, my lord, which has been harping, petitioners harping upon, my lord. Rule 23 is subject to rule 5, my lord.
Rule 23.
Lordship, I have annexed rule 23 at page 78, Lordship. Annexed 20.
Yes, what about this rule 23?
Lordship, my submission is that they have violated the rule 23 sub-rule 2. All mining querying permits in respect of clauses 1 and 2 mentioned under sub-rule 1 shall be granted following a competitive bid process unless specifically decided otherwise by the government in any specific case. Lordship,
So-
my humble submission is that the imprint permit that is at page 77 and exact 10 does not reflect such type of any decision by the government, Lordship. It's a normal MP, MLA fund and
Correct.
Then there.
You see, MP, MLA fund, there's so many projects, there's so many. In one district, there'll be so many what projects?
yes, like,
Building steps, building a house, what?
No, MPLAD, my lord, normally pertains to, my lord, emergency repairing of a road, my lord, a dam.
there is
No, no,
But my lord, I challenge the locals of the petitioner because my lord, petitioners, my lord, time was gone, my lord. It was
Lordship,
settled with him for
I-
2
yes, Lordship,
years.
terminated, but if that
To
has been
invoke
decided-
26, my lord, that Noor Khan Pathan's case has comes, my lord. What legal injury he has, my lord, suffered, my lord. Ayub Khan, Noor Khan Pathan covers his case.
no, but then what about this 23?
23 subject to rule 5, my lord.
Non subject to rule 5, but rule 5 requires specific projects.
My lord,
Now, when you say MLA fund, MP fund,
my lord.
which projects under those funds?
Untied funds, my lord. These are
Anti fund.
so these-
It's like, how, just tell me, how many MLAs are there in Assam?
My lord,
How many MLAs are there in
126
Assam? How
MLAs.
many? How many?
126.
126. Each MLA will get how many? How much fund?
2 crore,
But
my
here-
lord, they get, my lord, 5 crore, my lord,
5 crores project. Now, out of those 5 into 126.
my lord.
And how many, what projects are they going to do? You've got to specify the projects. You cannot just have a blanket, say that for this, for the projects under this. What projects? Are you building a Taj Mahal or you building
My
a?
lord, since, my lord, this.
I
it
don't
refers to-
know.
My lord, since it refers to Panchayat rural development, I'm very sure, my lord, it pertains to some civil work. I
So
don't know that-
you bring those,
Just
you show
tomorrow,
us
my lord.
what specific projects are being
Yes.
contemplated under this.
Then my lord will take it up tomorrow. my lord. I'll bring, my lord. Apart from that, the local stands, my lord. Locals is challenge, my lord.
Maybe,
My lord.
maybe.
I am also not a stranger, Lordship.
Huh?
Maybe they have terminated me, but that termination order is under silence and I have not.
Termination, my lord, due to
Suppressing
defaulting
also.
payment, my lord.
Tomorrow, Lordship.
On one hand, my lord, you don't pay up. Other hand, when we are losing. When we,
No, you see, one thing is very easy to say. That way you can say all projects in India are for public interest only. No project in India is for
no, my lord, don't actually-
private
it's a-
interest. It's all for public interest.
though it's embedded with the public interest, my lord, it's a government permit. But I'm very sure, my lord, I'll come up tomorrow, my lord.
Right. Heard, Mr. Heard Miss
M. Bora, Lordship.
M. Bora, learned counsel for the petitioner, who submits that the respondents have given them the mining area permit to whom? To the respondent number?
5, Lordship.
To the respondent number 5. Without any tender process being initiated, which is in violation of Rule 23,
Sub-rule 2.
Sub-rule 2 of the Assam Minor Mineral Concession Rules 2013. Pusta. Mr. D. Gogoi, learned counsel for the Forest Department, on the other hand, submits that Rule 5 of the Assam Minor Mineral Concession Rules 2013 carves out an exception for grant of mining permit for not to any department of the state or central government for project works to be done by the said department. Full stop. In this regard, he has relied upon the order dated 17/8/2022, passed in IA Civil number 2238/2022, in WPC number 2138/2022. Full stop.
Thank you.
Next, on perusing the impugned order dated
13 to
13 to,
impugn order permit 13 to 23 Lordship.
13 to 23, which has given mining area permit to the respondent number 5 from 10 to 23 to 16/6/23, comma. It is seen that the said permit has been given for implementation of schemes under MLA fund, comma, MPLAD, comma, UNTIED, Untied Fund, etc. No specifics have been provided in the permit, and the same is very generalized. Mr. D. Gogoi submits that he will produce the specified project works that are to use the minerals that are to be extracted on the basis of the permit, of the impugned permit. This is the matter tomorrow.
Obliged, ma'am.
Tomorrow on the prayer of Mr. D. Gogoi.
Ma'am, please allow. My lord, this case relates to my lord on the strength of a neighborhood certificate was cancelled, my lord.
Huh?
Neighborhood certificate was cancelled, my lord. On the strength of that, my lord, impugned settlement was granted to them, my lord. Thereafter, we made a complaint, my lord.
Just a
Then, my
minute,
lord,
what is this?
a settlement of fishery temporary
Was given to,
given to private respondent on the ground of the neighborhood.
on the
This
ground of
Neighborhood certificate.
Huh? Neighborhood certificate.
Neighborhood. Then, my lord, that neighborhood certificate was cancelled, my lord.
Okay,
They cancelled by the authority. On the strength of that, he got the settlement daily basis without tender. Thereafter, my lord, I made a complaint to the authority, my lord. Authority fixed a date for hearing, my lord, and subsequently passed, my lord, impugned order by the last page, holding that, my lord, that the last page is the 99, my lord. Holding that, my lord, it has been cancelled for the hearing, my lord.
for the hearing,
Hearing has been cancelled.
hearing has been cancelled.
Cancelled. On the strength of, my lord, she relied some cases, my lord, which I have.
When was the fishery settled with the neighborhood? Neighborhood what? What is the word you use? Neighborhood
My lord, I'm coming. to that.
society? What?
Yes, my lord. Page 57, my lord, temporary settlement was given 3rd January 22. Page 55 be seen, my lord, for a moment. Page 55. Last operative part, my lord.
Where?
Page 55. It appears from the document submitted by the petitioner society that society is considered 100% actual fishermen, scheduled caste community members and reside within the neighborhood of the fishery. This neighborhood certificate, lordship will see page 56. Lordship will see the page 56.
Yes,
The neighborhood certificate that was cancelled by page 57.
It's not that, it's just that they are in the neighborhood.
Yeah.
This society is different.
Yes, my lord, same society was being given, who is running the private respondent number 5. So my grievance is that, my lord, hearing was started by issuing a notice on we made a complaint, my lord, at page 80.
So, no, right now, is the fishery given to anybody?
Yes, sir, they are running, we are not onto that, the fishing, my lord. We are onto that, my lord, we made a complaint. We notice have been issued. The next day you said that hearing has been stayed, cancelled.
But what right of yours has been violated?
My lord, I'm the immediate neighborhood, my lord. They are the outsider. They are the outsider.
Okay, the fisher.
Yes,
Okay.
my lord. Lordship will see page 80, my lord. That will be clear. Page 80, my lord. Lordship has come across, my lord.
Yes,
Forwarding letter so and so complaint received from so and so Dibru, part one means Samavai Samiti against on the basis of the settlement daily basis, so and so. Then, my lord, page 81, hearing was started. And we have been asked to appear on 29th. We have been asked, my lord, page 81. You are hereby asked to attend the hearing to be the secretary to the Assam Department, chamber number so and so, Janata Bhavan sir, with the president of the society and member of the society legal.
yes, who is appearing for the
Lordship,
fishery?
just a minute, my lord. Then, my lord, what happened, my lord?
You want a hearing basically, so we'll direct a date.
My lord, I want that.
You want a date, that's all.
Yes. My hearing.
Yes, Mr. Chaudhary. what is that?
I'll appear for the respondent number 5, but
So, yes, so he wants a date to be fixed for the hearing, let a date be fixed
question
for.
is like this, my lord. There are several petitions pending. And my learned friend has already challenged my neighborhood. My settlement, that is, my lord, on daily basis, that has been challenged by him on the ground that I don't have the neighborhood certificate. That is his case in the writ petition.
Ah,
And those writ petitions are already, my lord, taken, ready for disposal, fixed for, my lord, on after the Bihu. Now, my lord, the same issue which has been raised before this honorable court regarding my neighborhood, that is the, my lord, subject matter in the writ petition, and now during the pendency of the writ petition, they have filed a petition before the authorities.
there should be a hearing on that.
Yes, my lord. Then we had approached the authorities saying that the matters are pending before this honorable
The
court.
sub judice.
Sub judice matter, you cannot hear it. And the matter is ready for hearing, all the matters can be heard together, my lord. The writ petition numbers are also given in the impugn order.
My lord, I'll clarify, my lord. The writ petition which have been filed challenged his settlement. Neighborhood was never challenged in any of the writ petition.
Settlement.
Neighborhood was never challenged. I don't understand.
Neighborhood certificate, raising this cancellation certificate.
Whose
Was
neighborhood certificate?
the private respondent number 5.
That is under challenge in the writ
No,
petition.
there is no, I have not challenged. I have annexed all the
My
orders.
lord,
Huh?
on that ground.
I have
they
all the
challenged
order.
My settlement.
On
My
that
settlement
ground,
has
you
been
can.
challenged on the ground that I don't.
You
have a
bring those
proof.
files, we see, you have taken a stand right now.
Yes, my lord, I have annexed, my lord.
You have
I
next,
have annexed all the order.
let's see.
Lordship will see page 82.
82.
82 is the reflected in the order, my lord, is no
My
considering the
lord,
same
my difficulty
code
today
is that
my lord,
rather
we
not
didn't
is
have a
equal
caveat.
to pass interim
My
order.
difficulty today is that, my lord, we didn't have a caveat. We have appeared by filing Okaratnama. I don't have a copy of the writ petition also, my lord.
Anyway, let us see, let's
My
clarify.
Lordship will see page 82. First writ petition filed by somebody else, my lord, which have been reflection in the impugn order. There is, my lord, taking consideration of the view present is not inclined to pass interim action, however, liberty granted to the appropriate application if the action is sought to be taken by the respondents. Submission of so and so. Then another writ petition which I have filed. That your lordship will see page 86. Operative part starts from page 88.
Here the Dibru part 1 means Samabai.
Samiti, I am the one. man. Then lordship will see page.
Just
88.
just a minute. Respondent number 10 is Dibru Dangori part 1 means Samabais. This is not this, this is what they're challenging.
No, my lord. I challenge what, my lord? Specific, my lord, hearing was taken, please.
No, no, Mr. Counsel, you please come
Lordship.
to, just a minute,
Lordship,
page 89,
my lord.
third last para. It is contended by the petitioner that the respondent number 10 society is not in the neighborhood of the fishery. So.
Is
So,
presently
so
managed by one
you
man.
have challenged this.
No, my lord, I have not taken that.
You are representing whom? The
Restaurant number 10 there might not now, here might not be private, restaurant number 5.
out here respondent number 5.
Madam.
Okay. So respondent number 10 in that.
Yes, fine.
So yes, you've challenged here. You've challenged. It is contended by the
My
petitioner.
lord, I contended, but his neighborhood certificate we obtain later on, my lord.
Whatever it is, yes, the issue is the same.
My lord,
Then
I
your
issue there is that, my lord, in the read petition, I was the sitting lessee. I was not being given to an outsider.
Ah.
That plea I have taken.
Ah,
That is my case.
now now also the same case.
No, my lord.
Now-
Now, my lord, he is enjoying with a fraudulent document. I made a complaint. Authority fixed the
Correct,
date for
but
hearing.
then the neighborhood, you see, right now, you want the fishery on the ground that you are in the neighborhood and that he's not in the
No,
neighborhood,
my
correct?
lord. In the instant read petition, my lord,
Petition.
instant read petition, I don't want fishery. I want to, my lord, hearing to take place.
So
That is my limited prayer.
correct. Now we will decide whether your limited press should be allowed or not.
Yes, yes, that your lordship will
So
accept.
we are, so my question to you is, you have been questioning whether he is in the neighborhood or not in the earlier writ petition.
No, my lord, that
It
read
is there,
petition
it
I'll
is there,
bring-
it is very clear.
Lordship will do like this, my lord, fix the matter tomorrow.
I
I'll
am
come
dismissing your case.
along with that, my lord.
You know, you don't want to hear me, why should I hear you?
Lordship,
I'm trying to
lordship, lordship.
ask you questions, you're
sorry,
not
sorry,
hearing.
my-
No, but
Sorry, my,
you can go to division bench.
my lord, that cannot be.
Heard
my lord.
Mr. J.I. Borbuya, learned counsel for the petitioner,
Fix tomorrow, my lord,
Who
I'll come with the read
submits?
petition, my lord.
that the impugned order dated impugned order dated
28-3, man.
28/3/23
My lord.
passed by the Secretary to the Government of Assam, Fishery Department, by which the date of hearing on the complaint lodged by the petitioner against the respondent number 5 has been cancelled, should be set aside. And also, he further praised that a fresh date should be fixed for hearing of the petitioner's complaint by the by whom? That has to be heard by whom?
By my lord Secretary, Fishery Department.
By the Secretary to the Government of Assam Fishery Department. Full stop. Next para. Mr. M.K. Chowdhury, learned senior counsel appearing for the respondent number 5 submits that the issue whether the respondent number 5 lives in the neighborhood of the Dibru Part 1 Fishery Mahal is already sub judice in WPC number
520/2022
520/2022
and 728 of 22.
and WPC number 728/2022, which is fixed for hearing,
For admission hearing for disposal.
which is fixed for admission hearing for disposal
Immediately after the.
immediately after the Bihu festival. Full stop. He accordingly submits that in view of the above, accordingly submits that in view of the above, the writ petition should be dismissed. Full stop. Who is appearing for the state? Mr.
M.
M.
Setia,
Chetia appearing for the
1 to 4.
correspondence number 1 to 4. Also submits that the issue that is sought to be that is being raised by the petitioner herein would be decided by the would be decided at the time of disposal of WPC number 520/2022 and WPC number 728/2022.
Madam.
And as such, there is no requirement of having a hearing on the said issue during said issue, full stop. I have heard the learned counsels for the parties, full stop. On considering the fact that the petitioner herein has taken a stand in WPC number 520/2022 that the respondent number 5 is not in the neighborhood of the fishery and as such could not have been given, could not have been settled with the fishery, comma, correct? This court is of the view that the complaints against the respondent number 5 in any event would be considered in WPC number 520/2022, full stop. Accordingly, the cancellation of the hearing with regard to the above issue by the respondent number,
Secretary, my lord.
by the respondent number 3 does not suffer from any infirmity as the subject matter in issue is already sub judice before this court in the above cases. Full stop. As the above cases are being, as the above cases referred to in the foregoing paragraphs are to be disposed of after the Bihu festival, comma. The grievance of the petitioner would be decided by this court at the time of disposal of those cases. So accordingly, this court does not find any ground to interfere with the impugned order dated 28/3/23 passed by the respondent number 3. The writ petition is accordingly dismissed.
May I please, your lordship? I think this case pertains to withholding of the sale permission, lordship, without giving an opportunity of us.
Huh?
Withholding of sale permission.
State provision.
Sale permission, lordship, for sale of property without giving any opportunity of hearing, lordship.
Disposal, they've disposed it of, not
They have not
disposed,
disposed, they have withhold,
kept it.
kept it in abeyance without informing us, without anything, lordship, without any express stay or injunction of any court.
Okay. So what is to be done? Who is for the Tinsukia Municipal Board?
Notice should go, my lord.
Huh?
For that, respondent notice should go, my lord. Otherwise, my lord, title should be pending, my lord.
Huh?
Title should be pending regarding.
Okay, title suit is pending. Then,
Title is pending, but lordship, title,
where is the question of them deciding when your title is in question?
lordship, the
Yes, sir.
tenant has filed a
Huh?
title suit. Whether the tenant has filed a title suit. If that being so, lordship, then all the tenants may file similar objections before and get the whole of that sale permissions, lordship. So the title is not in dispute, lordship. It is
Then,
not disputed in that notice be issued, lordship.
Heard, Mr.
A Kakoti.
A. Kakoti, learned counsel for the petitioner, who submits that the Tinsukia Municipal Board has not taken any action on the application made by the petitioner for giving sale permission of the property covered by. Where is the,
There in under,
Huh?
in Tinsukia.
for the property for the property, uh, uh, covered by dark number 4259, bracket part of periodic pata number 951, comma, situated at 80 Road, Tinsukia Town, sheet number 10. And para 2 of the writ petition is there. Is this correct? Para 2 is correct. no? Good stuff. The petitioner's counsel submits that though title suit number 52 of 2022 is pending in the court of the learned Munsif number 1, Tinsukia, filed by, who is this? Who is this? Filed by the tenant. Filed by the tenant, comma. The same cannot be a bar for considering the petitioner's application. Full stop. Issue notice returnable in 4 weeks, Mr.
Consider for 1, 2 and 3, madam.
1, 2 and 3. Petitioner takes steps for service of notice upon the respondent numbers.
4.
Respondent number 4. By registered postal daily within 3 days. This is the matter after 4 weeks.
Keep me obliged.
May I please your lordship. My senior SCKL, he's on legs, your lordship. Can you pass over the matter?
What is the case, Mr. Bhatt?
Lordship, the case is like this, your lordship. A the petitioner who is a businessman, he has received a demand notice from the GST authority, your lordship, amounting to 48 lakhs, your lordship. And 3 of his accounts have been, your lordship, freezed thereafter, your lordship, by the bank. I am, your lordship, against that, I have already prepared an appeal, your lordship, before the authorities, your lordship. Now, so far as this freezing of these accounts are concerned, your lordship, I am relying on a office memorandum, your lordship, that is at page 35 of my petition.
Yeah.
Your lordship, this is dated 16 September 2014.
Yes.
Amendment to the appeal provision in customs centralized service tax made by so and so. Then your lordship will kindly come to page 36, clause 4.
Yes.
Recovery of the amounts during the pendency of appeal. Height circular number, first part not required, 4.2. No coercive measures for the recovery of balance amount, that is the amount in excess of 7.5% or 10% deposited in terms of 35F of Central Excise Act 1944 or Section 129 of Customs Act 1962 shall be taken during the pendency of the appeal where the party SSE shows to the jurisdictional authorities proof of payment of stipulated amount of pre-deposit of 7.5% oblique 10% subject to the limit of 10 crores as the case may be, and the copy of appeal memo filed with the appellate authority. I filed, your lordship, I have annexed the copies, that is page 29. Now I have informed the authorities also, your lordship, by page 39 representation. Now this has not been released, your lordship, not been defreezed, your lordship. That is my case, your lordship. This page 29, if your lordship takes up,
Have you taken up this issue with the appellate authority?
lordship, that is at page 39. I have detailed, in detail, I have mentioned everything, your lordship. Prior to that, your lordship,
What is the date?
I can
Of this
still
letter.
respond.
this was your
Names.
lordship. This is your lordship, 4th of March 2020.
For the March.
Your lordship,
4th of March.
March.
pertaining to that your lordship order in original that is issued on 9/3/22, annexure B, page 21. In this regard, your lordship, order in original has been passed by Assistant Commissioner of Tezpur, your lordship.
Just a minute. Page
21,
Yes.
annexure B.
In fact, your lordship, I have
Discussions
just
and
one more fact, your lordship.
Discussions and findings, your lordship may please to turn page 25.
No, this page, okay,
This is the order, your lordship, demand.
Huh?
This is the demand. This is the order.
No, what about this page 39? Has this been decided?
No, your lordship, that has not been decided, your lordship. That's the issue. That's why I am before this honorable court.
But then, so it will decide.
Lordship, let them, your lordship. Because your
Let them
lordship-
decide. So
Let them.
why are you coming so fast?
No, your lordship, the problem is.
When did you serve it to them?
This is your lordship, 4th of March itself, your lordship.
So why have you come now? Let them take a decision.
Lordship, let them take your lordship.
You are coming here to fix a date for them, basically.
Lord.
You wait for some time.
Even otherwise also, your lordship.
Yes, the month has passed.
Lordship.
Today is 4th of April.
No, your
Five of-
lordship will kindly see this circular, your lordship, page 35. It says, your lordship, no coercive measure for the recovery, your lordship. Now my account has been freezed.
No,
These
no,
are all
but you go to
business
them.
accounts.
You have already, you go to them. Why should we interfere?
Other
Lordship,
alternative remedies
They may be
available, your
directed to
lordship.
take a call on my petition, your lordship.
You wait, where is we do not know.
Your lordship, let them take instruction, your lordship, if they have anything to state before this
No,
honorable court.
Why should we waste time with it? They will take a decision on this.
No, your lordship will kindly see 1 month is sufficient time, your lordship.
As a council, you see, 1 month is sufficient. No, according to you, it is sufficient. According to them, you think that you are the only case they have in the
No, your
entire
lordship,
northeast.
kindly see my business is your lordship. My whole business accounts, your lordship, are under this, your lordship, seized, your lordship. They have freezed it. I have not been able to operate. One of them is your lordship, my hotel, your lordship.
Anyway, you take a decision on his letter, that's all. Heard Mr. S. Bottom, learned counsel for this.
Let my senior be appear, your lordship.
In that case, your lordship may fix it day after
No,
tomorrow.
we're not.
Of
We're
course,
going to be very
lordship is
busy.
that is going on, your
We are
lordship.
going to be very busy.
Tomorrow, your lordship.
Platinum Jubilee doesn't come every day.
Lordship, I know.
It comes after a few years.
On,
I don't think you will see the next, most of us will not be here for the next after another 75 years.
lordship,
Then
That's-
probably grandchildren will be here.
lordship. On 11th, then your lordship.
No, we're disposing it today.
Yes, sir. Deeply oppressed.
Please, your lordship.
My lord, this is a case of issuing a impugn tender over a private property, your lordship. Before going to the impugn tender, your lordship, I would like to show your lordship our position over the land. Page number 18, your lordship. It's a Jamabandi. It's in our name. We are the petitioner society, your lordship, registered under the Society Registration Act. The land, we have the right interest entitlement over the land.
So what is your case?
Cases, they have issued the impugn tender over a land to establish, to set up a weekly bazaar, chok bazaar at page number 22. At page number 22 is the impugn tender, your lordship. Under which law, your lordship? We are the regular payee of land revenue, your lordship. No, our land is free from all encumbrances.
Which one? Kajal Gaon or
Yes.
Bartaloa?
Yeah.
Which one?
Kajal that
Kajal Gaon.
it's a private, it belongs to us, your lordship. We have submitted representation, but in vain. They have
Yes,
not,
what to do, Mr.
Currently that not page number 22 is the notice, tender notice is issued.
Yeah.
But it doesn't reflect that this is the land. It's only say that Kajalgaon.
No,
weekly
it is
chok
the land.
bazaar
it is the land.
On Sunday.
We have inquired with the municipality, we have inquired with the
They say
municipality.
they are the owner of
It is
the.
only part, your
number.
lordship. It is only part.
If lordship come to page number 6.
May your
paragraph
lordship
3.
interfere.
Just a minute, Mr. Council. We cannot
Paragraph
get
6,
to
page number 3, madam.
Huh?
Paragraph 3, page number 6.
page number 6.
They say they are the exclusive owner of the 13 bigha, 3 kotha and so land of tag number 298 and patta number 50. Is it the same land or not? That
We don't know.
that cannot be detected from the it's not the tender notice.
So is the market running now?
No, your lordship, it's a private land. What
Mr. Council, I know, I know what your submission is. Now this tender, has it been finalized?
No, actually, it was from 1/4. It was supposed to run from in the tender itself is mentioned, really reflecting from 1/4/2023 till now, because of our representation, it has not, it is still, but that means yesterday, from yesterday.
Now who is to decide? This is a question of fact.
Yes, Lord.
Now who will decide? This High Court cannot decide.
The issuing of that-
Whether the tender pertains to your land or not, we do not know. We have to take a report from the concerned
Municipal
person.
board, my lord.
Which is, so
Already a representation pending, my lord. The chairman is on. Lordship will
so
find it
take a
paper 31.
decision. Take a decision on the representation.
Let the matter be disposed of, let the representation be disposed of. Till then, let this tender be
Okay,
stayed, your lordship.
Lordship will, they'll take a call within a week, my lord.
okay. Heard, Mr.
My name is A. Nazar, your
Let her come. Oh. Heard Mr. A. Narzari, learned counsel for the petitioner who submits that the petitioner is the owner of land measuring 13 bighas, three kathas, 15 lechas, covered by DAG number 298 of periodic patan number 253 of village Danga Gaon under Sidley Revenue Circle in Chirang district, BTR, SM. Para 3, it is there, huh? Para 3. The petitioner's grievance is that the Kajal Gaon Municipal Board, that is page 22, has issued a tender notice dated 2/2/2023 for running the Kajal Gaon Weekly Chowk Bazaar bracket every Sunday.
Well, the pure.
On the land of the petition. Full stop. The next paragraph, the petitioner's counsel submits that the petitioner has submitted a representation against the said tender notice dated 2/2/2023. Wide representation dated 24/2/2023. Full stop. However, the petitioner's representation has not been decided by the respondent number 7 till date. Full stop.
7 and 8.
Mr. S. Bora, the learned counsel for the respondent number
2 and 3.
2 and 3, submits that there is nothing to show in the tender notice dated 2/2/23 that the land of the petitioner is going to be used for the Kajal Gaon Weekly Chowk Bazaar. Full stop. He however submits that the issue can be decided by the respondent number 7. Full stop. Next para. In view of the consent of the parties, the respondent number 7 is directed to take a decision on the petitioner's representation dated 24/2/2023 within
Within a week, my lord,
within a week from today.
from today.
But who will give the copy of the order? You will give
Well, I will forward it. But
within a week, is not
his duty
possible.
is to,
Within 10 days, within 10 days from today. Full stop.
but his duty is to.
No, your lordship.
Supposing he will not give.
He will not give that.
That is what.
That's the difficulty.
I will forward it, man.
Within 10 days from today. Full stop. The same is subject to the counsel for the petitioner. No, within 10 days from today. Full stop. Till a decision is taken by the respondent number 7, the tender notice dated 2/2/2023 should not be acted upon.
Yes, your lordship.
Full stop. The above directions are however subject to the condition that the petitioner shall submit a copy of this order to the respondent number 7 within 3 days from today.
Please, your lordship.
Huh?
While applying.
Within 3 days from today. No, you just, it'll come, you don't have to give certified copy. You give I've said copy only. I didn't say certified. It's there in the website. It will be uploaded today itself.
Let it be uploaded to the.
It will be uploaded today itself. You also give, but in the meantime, they can also have some signature. We gave it to the office,
Lordship.
clerk signature is here or something like that.
Highly obliged,
The writ petition is accordingly disposed of.
highly obliged.
Problem.
Well, the petitioner entered in the contract for construction of the railway line, my lord,
Items 20.
along with some tunnels, my lord.
Huh?
For petitioner entered in the contract with railway for construction of railway line with tunnels. But there was just some misalignment of the tunnel, my lord. So railway directed him to rectify the same because in their drawing, my lord, some mistake was here. So we rectified it. The tunnel length was increased. So for that, they have made the payment. But subsequently, a committee was instituted. They were directed us to refund my lord 6 crore and odd. We approached this honorable court, my lord, in the writ petition that we have also find that at page 66. And this honorable court, my lord, they state that order, my lord, refund and directed us to go for arbitration because arbitration clause is there, my lord. If your lawsuit will come to my lord, page 69, my lord. 68 is there. Last para.
Yes.
In view of the same, since I am ready to arbitration required by 1, so, and no coercive measures if you taken, my lord, that is. Different.
69, yes.
Yes. So interim order is continue, my lord.
Yes.
Now, my lord, Arbitration and Conciliation Act was amended in 2015. This agreement was 2010. If your losses takes up by the Arbitration Act, my lord, section 12(5), my lord.
Yes,
12(5), my lord. 12 subsection 5.
yes.
Notwithstanding any prior agreement to the contrary. If there is a prior agreement. Any person whose relationship with the parties or the council for the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as arbitrator. So, my lord, this is the clause and the 7th schedule is here. Now, what happened? The railways has amended the clause 64, my lord. If your losses comes to the modified clause, my lord, page 20. Earlier, my lord, they were appointing their own officers, my lord, who were serving. Now they have modified it. They in place of serving, they have given the retired railway officers. If the losses appointment arbitrator where applicability of 12(5) the act has not been waived, the arbitrator tribunal shall consist of panel of 3 retired railway officer, retired not below the rank of SAO officer, arbitrator. For this, my lord. Now, my lord, what happened? In this matter, my lord, this matter was, my lord, went up to Supreme Court. My lord. In Supreme Court, my lord, if your office will, my lord, I am giving the copy of the judgment. In the Parkins case, my lord, Supreme Court has considered this clause, my lord. Whether this is in accordance with the section 12(5) and reviewed schedule of the act, my lord. If the lordship will take up, my lord, first case, the Parkins case. Para 20. Para 20. My lord, I beg my apologies. Para 20.
Yes.
Yes. We does have two categories of cases. The first similar to one dealt with CRF Limited, where managing director himself is named as an arbitrator with an additional power to appoint any other person as arbitrator. In the second category, the managing director is not to act as arbitrator himself, but is empowered or authorized to appoint any other person of his choice or discretion as arbitrator. In the first category of cases, managing director was found to be incompetent. It was because the interest that he would have be having in the outcome, the result of dispute. The element of agency would thus be directly relatable to and arise from the interest that he would be having in such outcome or a decision. If that be the case, similarly, similar invalidity, my lord, this is important. Similar invalidity would always arise and spring up even in the second category of cases if the interest that he has in the outcome of the dispute, he has taken the basis of the possibility of the bias. It will always be present, irrespective of whether the matter extends under the first or second category of cases. We are conscious that if such deduction is drawn from the decision of this court in PR Limited, all cases having clause similar to that of which we are presently concerned, a party to an agreement would be disentitled to make any appointment of an arbitrator on its own, and always be available to argue that the party or the officer or the authority having interest in the dispute would be disentitled to make appointment arbitrator. But here, my lord, the clause general manager is authorized to appoint the arbitrator. Now, this judgment, my lord, two judges bench. So, my lord, this judgment was upheld by a 3 judges bench, but on the facts, my lord, it was slightly, my lord, disputed. Well, if your losses come to the judgment, para 34, my lord, Parkin's case has been considered. It was affirmed, my lord. Affirmed. But in a para 37, my lord, next page, this case was, my lord, distinguished in the facts of the case. On the ground that they give a panel of arbitrators and one person, my lord, from the panel of arbitrators appointed as choice of the petitioner. So there is no difficulty. This judgment of my 3 judges bench, my lord, again, my lord, what happened? Considered by 3 judges bench of the Supreme Court in 2 cases. Your losses may just come to, my lord, first case. 114. Huh? 114, my lord. Page 114. Having heard K.M. Nagaraj, planners so institutional facts by case, the judgment of High Court cannot consider it. Accordingly, special division is displayed. However, reliance has been placed on the recent 3-bench decision of this court delivered on 1712 in so and so. Well, this is the judgment I have. So we have perused the aforesaid judgment and provinces disagree with it for the basic reason that once the appointing authority itself is incapacitated from referring the matter to the arbitration, it does not follow that notwithstanding these yet appointments are valid depending on the facts of the case. So we therefore request the Chief Justice to consider larger bench. Well, that Parkinson's case said that appointing authority cannot be same person who has the interest in the matter.
No, Perkins case said that appointing authority cannot be interested.
Yes,
Party.
yes.
And but can he appoint?
No,
He cannot appoint.
He cannot.
So that was upheld by this 3 judges bench.
3 judges bench upheld, but distinguish the facts of the case. This the distinguishing, my lord, feature has been again, my lord, referred to larger bench by this court. And again, another judgment is there, my lord, page 116. Supreme Court. Here your loss will find, my lord. Same has been considered. Para 6, my lord, page 117. We need not at this stage go into the correctness of the award, as those are necessary presently arising out of our consideration. They have quite clear that correctness of the decision of the central organization so and so, based on whose appointment was met, and the matter has proceeded before the arbitrator was doubted by a subsequent bench of 3 judges. In the circumstance, we directed the papers be present for the Chief Justice of India constituting a larger bench. And in the meantime, my lord, the award has been stayed. Now, my lord, in this case, what happened? When this honorable court, my lord, allowed us to go for arbitration, we filed a petition, my lord, for the general manager. If your losses come.
So in this central organization.
Yes, my lord.
Uh, the person who is unauthorized to be appointed,
Yes.
who cannot be appointed,
Yes.
he can appoint some,
He can.
he can appoint.
He cannot. That is why, my lord, because although Parkins case is upheld, affirmed, but on that tax. my lord,
On the second portion, second part, it was
Second part, my lord.
differentiated, I mean.
So that is why it was sent to larger bank. In this case, my lord, what happened? When we approach the general manager, if your losses comes to page 70, that is the applicable. Our opinion.
Page 70.
Page 70. 11, page 71, my lord. Where is the fourth paragraph?
Yes,
However, clause 16 of the additional special conditions of contact and railway board notification by appointed arbitrators by the general manager do not apply in the instant case with the pronouncement of the judgment by the Honorable Supreme Court, chapter 11(1)(21), in the special leave appeal so and so. Union of India versus Sankhya Construction. A copy of the said judgment is enclosed herewith and marked as encouraged. My lord, that first, my lord, that referring the matter to a larger bench, that we have enclosed. We said the general manager has no power. But in spite of that, my lord, what happened? The general manager has sent us the 4 names, page 72. My lord, if you'll also see the 4 names, A.K. Mittal, Radhesham, Akhil Agarwal, and Harshman. We are compelled to, my lord, give the 2 names, out of which 1 name will be on our account as our arbitrator. And 1 will be appointed by the railway, then presiding arbitrator will be appointed by the railway. Now here, what happened, my lord?
just a minute, let me go back to this.
Yes. Harkin's case may be seen, my lord. That's it. There are 20, my lord. Last.
So these persons who have been, okay. So but the annexation 9,
Yes, ma'am.
they are allowed as per the central organization judgment.
Yes. They have said it, but that judgment, my lord, in fact, my lord, Parkins case, if you'll also see, his Parkins case says the general manager has no power.
No, general manager has no power. That is there.
Yes.
But then he has got a right to appoint some
But
further
no,
persons.
Parkins case said he had no right to. appoint.
Correct. Perkins, but no, but the next judgment,
next
judges bench says that.
That is why, my lord, next judgment in the facts, my lord,
Ah,
again, that matter has been left to larger bench,
correct.
my lord. Now, if you
So,
also
so,
see,
so what is wrong now with page 72?
my lord, that is wrong, my lord, because we have said, my lord, that matter is for the larger bench. So why he should appoint and.
So,
again-
so you, right now you want everything to be kept in,
Yeah, bench, my lord.
in
Yes.
the status quo.
My lord, because all the 3 persons have been appointed from this list. If you also see at page 74. How biased it is, my lord.
Appointed by whom?
General manager, page 74, if you also see, all the 3 persons, my lord. Appointment,
Oh,
one,
but
for-
actually you should appoint one, they should appoint one and then.
I only nominate, my lord, they are
Ah.
officers. I cannot appoint one, my lord.
Oh, okay.
My lord.
As per their
As per
clause.
their list. And they appoint this is the fallacy, my lord. This is the fallacy. That is why Supreme Court, my lord, referred the matter to larger bench. And the matter is pending before the larger bench now.
So you want it to be kept status quo as on
Bench,
date.
my lord, because we have filed a petition, my lord, before the.
Yes,
tribunal
what to
judgment.
do, Mr. Chakrabarti?
Lordship, kindly come to page 68, Lordship. The last paragraph, Lordship.
Yes,
Page 68, Lordship. The matter was referred on the basis of the writ petition filed by the writ petitioner, Lordship, and it was agreed upon, Lordship. So as per clause 64 of the GCC, the arbitrator matter was referred.
where,
to
let us
arbitrator.
see the last paragraph, what does it say?
Page 68, Lordship.
Yes, I've got it.
Lordship. Thereafter,
Yes.
Lordship, we have asked the petitioner to nominate his Lordship, page 73.
Just in view, page 16, in view of the same and agreed to by Mr. Sahewala.
Yes.
There's a very, you know,
Ready to
that-
demand for arbitration as required under clause 64(1) of the GCC. This.
It is correct, my lord. High Court has directed us, my lord. We are not on that, my lord. We say that general manager has no power to appoint it. At first 64, let them appoint, my lord, but
Let me
somebody
finish
else.
my, if my senior permits me, Lord.
This is the law of the land, my lord. After the Supreme Court judgment in the, my lord,
Lordship, page 73, Lordship. We asked him to nominate Lordship and he nominates Lordship, the writ petition, Lordship. He gave his consent, Lordship.
Let us read page 73.
Lordship, to the general manager so and so, construction of so and so. Dear sir, pursuant to the Honorable High Court of Guwahati order dated so and so, under contract agreement but so and so, and in response to our letter dated so and so demanding arbitration, we have been asked by the NF Railway by letter number so and so to select two names for panel of 4 names of retired railway officer for appointment as nominee arbitrator from our side. We accordingly select the following names, Lordship, A.K. Mittal and Akhil Agarwal. These are the two he nominates, Lordship. Now,
my lord, this is without prejudice. If you'll also see on the top, without prejudice. That,
Lordship,
because I was compelled, my lord.
Lordship,
I cannot, we have categorical pleading at paragraph 14, page 35. In this regard. When the law is well settled, my lord, how he can do that, my lord?
But you have given your consent. The law may be whatever.
Statement of claim has also been filed, paragraph 16, Lordship, page 38.
Without prejudice, my lord, without prejudice. Because in the
Statement of defense has also been filed, Lordship.
in the past letter, we have said, my lord.
Statement of claim has been filed on 12/9/2022, Lordship.
And why, my lord, this?
Lordship, whether it is now open for them to turn around and say that he has no jurisdiction, Lordship. There is no stay order that all proceeding will be stayed. Matter, so whatever will be the law enforced, that will prevail, Lordship.
My lord, this second judgment order of the Supreme Court, you will also seen. In that case, award was passed. That has been said by the Supreme Court. They say that if that is reversed, my lord, the award will go. Then why this exercise should be continued, my lord? I am not asking for anything, my lord. I am asking that the matter will be kept in abeyance till the Supreme Court decides the larger bench decides the matter.
Lordship, may kindly see the impugned order, Lordship. It says they at no point of time raised this the question on constitution of the tribunal that has been stated, Lordship. Page 155.
150, that is the arbitral tribunal's order, my lord.
Point number 3, Lordship.
One at a time, please, one at a time. Let me hear him.
Point number 3, Lordship.
Point number 3, yes.
The claimant had not raised any
Just a minute,
objection on the constitution of the
153.
tribunal.
151 or 153? Which page?
155.
Yes.
The last annexure, Lordship. Point number 3, Lordship.
Yes.
The claimant had not raised any objection on the constitution of the tribunal prior to submission of this application. So he has not raised objection on the constitution of the tribunal at any point of time. He submitted statement of claim, statement of defense, and in the midway here, Lordship now has the file with the petition, Lordship. And there is no stay order, Lordship. So whatever will be the law enforced, that is the central organization of railway electorate, that law will prevail, Lordship.
Statement of claim
Filed on 12/9/2022.
on,
12/9/2022.
and then
Statement of defense has also been filed, that has been stated in Lordship.
when?
That date has not been mentioned, Lordship. In this page 155, point number 3, Lordship. The statement of defense has also been filed within the stipulated 6 months as per section 23(4) of the arbitration conciliation. Now this Lordship, the 6 for rejoinder, Lordship.
How many arbitrators are there?
Three.
three lordship. That is AK Mittal, Akhil Agarwal.
Where do we get that?
Lordship find at page 74. Lordship find at page 74. AK Mittal, Akhil Agarwal and Harsh Kumar.
Where is that general clauses of contract that change that has been made?
That is not part of the.
Page 19.
Huh? Page 19,
Page 20.
page 20. Page 20. So basically that is the question. So you have agreed to arbitration,
Lordship.
but now because of the Supreme Court judgments, you want it to be you wanted to be kept in abeyance. That's the basic.
My lord, from the very beginning, my lord, we have said, in the first appointment letter, my lord, we have approached the gentleman there. We have said that this is the Supreme Court view, so please don't appoint it, my lord, by any person. You have also seen, my lord, that page 70, my lord, page 71. Page 71, my lord. That page 70, the letter I have given after the High Court order. At page 71, my lord. Page 71, we have mentioned about the Kantia construction order. By the Supreme Court. Page 71. Therefore, we request you, the General Manager NFL Maligaon, Assam, to appoint an arbitrator who does not fall under a category section. Now, what happened? You'll also see, the list has been given in 4 names, page 72.
Just a minute. Yes, then.
List is page 72, 4 names.
Uh,
You'll also see the names, my lord. Eka Mittal, Rajesh Cham, Akhil Agarwal, Harsh Kumar. Now, who has been appointed by the my lord railway? You'll also see at page 74. Eka Mittal, he will be the presiding arbitrator. My lord, all the railway. Akhil Agarwal, my lord, he is contractor Samini.
What does your agreement say?
My lord,
Agreement, let us see a arbitration clause in the
the
agreement.
arbitration clause 64, they have amended by the 2015 amendment. They cannot do it, my lord. That is what Parkes case said. The general manager is absolutely not cannot appoint the arbitrator because he is the interested party. That is why 3 arbitrators are appointed by them. But normally what happens, my lord, one by one party, one by other party, and 2 arbitrators appoint the presiding arbitrator. Here, the general manager himself appointed the presiding arbitrator, their nominee, as well as our nominee, actually. How that can be done, my lord? That is why, my lord, the Supreme Court, Parkes case has been upheld, my lord, affirmed by the ECS case. but only facts, my lord, there. So proceeding will collapse, my lord. Why this exercise should be done, my lord? In the second case, Supreme Court has, in one case, my lord, High Court has appointed the arbitrator. Because Supreme Court has already referred the matter, Delhi High Court has appointed at page 119. Delhi High Court said in the view of the, this fact, but in the view of Parkins case, we are appointing the High Court. That matter. Delhi High Court, your losses may see page 119. Hmm. 153, my lord, operating court. 152. From
Yeah, page,
153. My lord,
just
your
a minute,
party-
just a minute.
property person 153, 119 it starts. In the present case, it is seen the panel arbiter sent by the respondent contain only 4 names, which cannot be considered be broad-based by any extent of imagination. Thus, the said panel as given by respondent does not satisfy the concept of neutrality of arbitrators as held by the Supreme Court in the case of so and so. Further, as already noted by the Supreme Court, has already given a permissive view with respect to the correctness of the judgment in central organization so and so, wherein a similar clause was considered and has passed reference order for constituting a larger bench to look into the correctness of the said judgment. In view
Which page
thereof,
are you reading? Which page are you reading?
page 153, my lord, page 153, para 31.
Yes.
Delhi High Court, my lord. Because it will also see in the present case, it is seen that panel of arbiters are sent by the respondent contain only 4 names, which cannot be considered the broad-based. You also got it, madam? By any external imagination. So the bypassing my lord said clause 64, my lord, the Delhi High Court has appointed as because Parkins case has laid down the law and subsequent decision has been referred to larger. Therefore, to distinguish the facts of the case. And we will not be prejudiced, my lord, if it is paid for about 6 months, my lord, suppose the Supreme Court decides it. Why this exercise should be done? And these arbitrators, my lord, has given a.
But why did you take part in the first instance? Why
My lord,
didn't you come to this court? Why
I had
didn't
no
you
other
challenge?
alternative, my lord,
You
because-
focus. How focus?
while writing the letter for appointment arbitrator, I still say that this is the law. In spite of that, general manager compelled me.
Then you,
That-
instead of giving your statement of claim, you could have come here.
Well, at that time, my lord, I did not come, but subsequently, my lord, we have filed a petition. Subsequently, and my lord, your lawsuit see they have what the undertaking they have given, page 76, my lord. How members are given the undertaking as per 7 schedule. Is it correct, my lord? Para 2. Page 76.
Just a minute.
Yes. The lawsuit got it. No? Page 77 is the 12. Your lordship got it. Your lordship may see only para two of that letter. That 76. As per the Arbitration Act, my lord, they have given this declaration. Para two,
There are two page
page 76, annexure 12.
76.
The members of the tribunal, your lordship got it, my lord?
Yeah.
The tribunal on their part declared that none of them has any past or present relationship in relation to the subject matter of the dispute, whether financial, business, professional or any kind. They also declared that none of them has any past or present relationship with or interest in any of the parties. So, can it be so, my lord? They were the retired officers, they are getting pension from there, they, my lord. Whether financial, business, professional, any kind, who is likely to be that. So this is wrong, my lord, absolutely. And my mere participation will not do, my lord, in the Supreme Court says, my lord, in the other case. That this it can be challenged, the petition, my lord.
The problem is that you are correct in a way that they have taken part. The other problem is the impartiality of the arbitrators
Lordship,
would always be a question mark.
lordship.
And how does it cause prejudice to anybody
Lordship.
if the matter is kept in abeyance for the time being?
Lordship, in
Because-
case it was decided in their, we will pay the interest,
Huh?
Lordship. We will pay the interest in case it is decided in their favor, Lordship.
Oh, they will say that because okay, so supposing it is decided in your favor, then who'll pay the interest?
Oh, well, I'm not on that.
You're not, will record your statement that you're not claiming interest. Supposing, or,
I'm not
for
claiming.
this period,
Yes, I'm not claiming.
and neither will you. And naturally, because you are actually asking for recovery of money.
Lordship.
They have my performance guarantee. Performance guarantee is also with them.
Lordship may fix this immediately after petition, Lordship. Nothing will happen in the meantime, Lordship. We'll file our, let me take the inspection, Lordship, and file our affidavit, Lordship.
Till then, it may be. The lordship.
Because once they have been participated, subject, filed their statement of claim, Lordship. In the midway, now they are raising all those things. They ought to have raised at the first instance, Lordship,
They should have, but then the problem is that
and there is no stay order.
there's no stay order. And
No.
plus, Supreme Court allows it also. In central, in that other case, Supreme Court has allowed this kind of,
That has been questioned, my lord.
it has been questioned, but that has not,
but
that's
case,
still, there is still a law.
No, Central has not my lord, overruled the parties case on this point. Only on factual aspect they have done it. Parties
Maybe,
has said that general manager has no power.
maybe. But then the Perkins case is only with regard to the appointment of that person.
No, an arbitrator also, my lord. the
Yeah,
general manager.
but then it does not, the subsequent three judges bench
Yes,
does not bar the appointment of an arbitrator by an unqualified person.
my lord, that is correct, but that case has not been overruled. That has been affirmed by this three judges.
Maybe, but the three
And-
judges
and that
bench
is why-
allows it.
That is why the matter has been referred to larger bench.
It impliedly overrules it.
My lord, that is why, no, that has been stated, my lord, the judgment that is affirmed. And subsequent three judges, two judge bench, my lord, refer the matter to larger bench. That is why. And that in the second case, my lord, the award has been stayed. They say that if it goes, the award will go. That is why, my lord, I am saying, my lord, that for 6 months, my lord, it may be stayed. That the Supreme Court decides it. What is the difficulty? I do not understand my lord. I am not,
Maybe he thinks he's going to win the case, that's
my
why.
lord,
Maybe he thinks he's going to win the case.
no, maybe, but I don't know, my lord, who will win, my lord, the arbiter. So let it come out.
I think you know, that's why you have come here.
Not that, my lord, because my lord, that I do not know, my lord, what parties think, my lord.
Otherwise, no one will come here if they're winning.
Anyway, my lord.
A person, only a person who goes to jail will come here, not a person who is winning everything. Anyway, You obtain the instructions, will decide this
Take
matter.
instruction.
This is a small issue, right? Third, Mr. G.N. Sahawala, the learned senior counsel for the petitioner. Who submits that the for
Appointment order is at page 74. right?
who submits that the appointment of the three arbitrators who are retired railway employees provide the impugn order dated 19/7/2022 should be set aside as the same is not in conformity with the judgment of the two judges bench of the apex of the Supreme Court in Perkins Eastman Architects DPC and another versus HSCC bracket India Limited reported in 2020 Supreme Court SCC 760. So 2020 will be size 2020 SCC 760. And no, first up. The learned senior counsel submits that as per the judgment of the apex court in Perkins Eastman Architects DPC and another Supra. The apex court has held that when the managing director of one of the parties to the dispute is ineligible by operation of law to act as an arbitrator, comma, the empowering of any other person by the managing director as an arbitrator would also be invalid. Correct?
Yes.
Gustav. Next para. The learned senior counsel also submits that though the law laid down by the two judges bench of the apex court in Perkins Eastman Architect DPC and another Supra had been upheld by the three judges bench of the apex court in Central Organization for Railway Electrification versus ECI-SPIC-SMO-MCML bracket JV bracket close, a joint venture company reported in 2020 14 SCC 712. Wherein it had agreed that the managing director of one of the parties to the case was ineligible by operation of law to act as an arbitrator, comma, it held that the said managing director could
But lordship in the central organization case, lordship para 38 said the lordship can read paragraph 38 also lordship. There is an express provision in the modified clause of general condition of contract as per.
That there, my lord. That-
That
Good,
is still considered-
good. Just a minute before I,
That has been upheld. Lord.
just a minute before, could 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 appoint arbitrators after a panel of at least 4 names of retired railway officers empaneled to work as arbitrators had been sent to the other party. For appointment as an arbitrator. The other party was to thereafter suggest to the general manager at least 2 names out of the panel of 4 names. And the general manager was thereafter to appoint. Three arbitrators to form the arbitral tribunal. Correct? Right. Next panel. The learned senior counsel submits that the decision of the 3 judges bench in Central Organization for Railway Electrification, Supra,
Page 114.
was not agreed with by 2 other, no, by another 3 judges bench of the Apex Court in Union of India versus MS Tantia Constructions Limited. Bracket. Special leave to appeal, bracket C, number 12670/2020. Wherein in its order dated 11/1/2021, it referred it requested a constitution of a larger bench to look into the correctness of the judgment passed in Central Organization for Railway Electrification, Supra, Pusta. Thereafter, another 3 judges bench in the case of JSW Steel Limited versus Southwestern Railway and another. I requested the Chief Justice of India for constituting a larger bench in view of the disagreement between 3 judges bench in Central Organization for Railway Electrification and Tantia also, huh? Next. The petitioner's counsel submits that the respondents had sent the names of 4 retired railway personnel to the petitioner, requesting the petitioner to nominate at least 2 names out of the 4 for appointment as arbitrators from their side. Via letter dated 18/5/22, issued by the respondent number 3. Listen. The petitioner thereafter selected 2 out of the 4 names for appointment of arbitrators by letter dated 15/6/22. Thereafter, the impugned letter dated 19/7/22 was issued by the respondent number 3, constituting the arbitral tribunal consisting of 3 arbitrators for deciding the dispute between the parties. Next paragraph. The learned senior counsel thus praised that though the arbitration proceedings have started, the same should be kept in abeyance till a decision with regard to the issue of constitution of the arbitral tribunal is decided by a larger bench of the apex court. Next. Mr. B. Chakravarti, the learned CGC submits that there is no stay of the decision of the, but there is no stay of the impugned constitution,
While referring the
impugned
matter-
letter dated, just a minute again, impugned letter dated 19/7/22, constituting the arbitral tribunal. Further, the same has been made in consonance with the judgment of the 3 judges bench of the apex court in Central Organization for Railway Electrification, Supla. He also submits that the petitioner has submitted a statement of claim before the arbitral tribunal on 12/9/2022, and the respondents have submitted their statement of defense. He submits that as the petitioner has not challenged, as the petitioner had accepted the jurisdiction of the arbitral tribunal earlier, he cannot turn around now and make a challenge to the same, just because a larger bench is to decide the question as to whether the arbitral tribunal consisting of railway officials could
Retired lordship, retired.
retired railway officials could form an arbitral tribunal on being appointed by the respondent number 3.
He also lordship nominated his own lordship, that is page 73 lordship.
He further submits that 2 out of the 3 arbitrators who form the arbitral tribunal have been nominated by the petitioner. And that's
Out of 2, only 1 for this one.
no, 2. You have nominated
Keep
2.
the 2 names,
Huh?
but they appoint only 1 for me, madam. Your lordship will see
Lordship,
the order.
we accordingly select the following names from the
Just a
same
minute, just a
panel.
minute.
That is one. If your lordship
You have given A.K. Mittal and Akhil Agarwal.
No, page 74, your lordship see, my lord.
73.
The 73, the four names.
No, 73 is you have given two names.
We have given two names, out of which one will be appointed on my behalf.
No,
71 notice may be seen, my lord. 72.
correct.
72.
72 is four names given.
Four
Then
names.
you have given two names. In page 73.
I have to give two names, out of which one will be appointed on my behalf.
Then you see how many have been appointed. You have given two names, page 73.
Yes, I have given two, because your lordship may see page 22.
No. Yes.
He will appoint the man of arbitrator, from one fully appointed for me.
You are requested to nominate at least two names.
Yes,
Now, you nominated two at page 73.
yes, I have nominated two.
Yes.
But
Now let us see if both these persons have been appointed as arbitrators or not.
they have been appointed.
That's what I'm
One
saying.
for the railway, one for me.
And one presiding.
One presiding, another presiding.
So that's what I'm saying. The persons nominated by you have both been appointed.
Yes, and another from the same list, my lord. I'll present.
Correct. So what is wrong with us? So what
Yes,
is
my
wrong?
lord, that is the, that is why I am questioning, my lord. The four names, my lord, for all the.
I'm dictating. What is wrong with my dictation? I don't know.
I know, I'm sorry, my lord, I'm not.
So where are we?
He further submits that two out of the three arbitrators who from the arbitral tribunal have been nominated by the petitioner.
I'm not by the petition. Awesome. That's what you have said. Awesome. Mr. B. Chakraborty submits that he would like to obtain further instructions in the matter. Awesome. When?
Immediately after vacation, lordship. Lordship may fix on 26.
26. Can you, my lord, 3rd of May, my lord? 3rd of May.
I don't know whenever you all want. No, he wants it, you want it earlier. I'm not giving any stay.
Lordship, then lordship, let it be on
Earlier.
19 or 20.
We can do,
20, let it be
20.
20, lordship.
20. List the matter on 20, 2022, 2023. So some notice is also issued on, you said,
Except for 1, 2, and 3, lord.
huh?
I accept.
No, I won't say, I won't issue notice better. I won't issue notice. I won't issue notice.
Yes.
Notices of no point. They've got nothing to say in this matter.
No.
We can issue notice also. But then there is no point. List the matter on 20. So on which date the question of the interim prayer shall also be decided.
Like. My lord, till then, my lord.
Nothing will happen, you know very well. There is a arbitration matter, nothing will happen.
Frequent dates are given, my lord.
On the next day, we'll see. On the next day, we'll finish everything. That hopefully. Yes.
My lord, this
What is this matter?
2 o'clock, my lord, almost 1:15 now,
27.
27.
Let us see what is this 27. Where is my problem? Yes, tell me,
My lord, shall I start? No, it's 1:15 already.
how long will you take?
10-15 minutes it will take.
Huh? 10 to 15 minutes?
10 minutes.
Well,
Because there is another reason why you start the arguments now. There's another reason. Your lordship, remember, last Friday, I started exactly at 1:10. And my fate, my lord, didn't click me. So.
Huh?
I don't want to-
they've been running 50 years.
Yes, it's eviction matter by the railway, my lord.
Eviction,
Yes, I'll just place the fact.
temporary shed made with CI sheets.
58 years
I
now.
do, have you got any, you're not the landowner.
No, that's the reason. That's the reason, because these particular shops might not being operated by these shopkeepers, might not vendors, cobblers. They've got saloons like that last 58 years. And the municipality is taking taxes from us, they're taking tolls from us under section 68. Section 68 says within limits of the municipality, it's municipal land. Now, all of a sudden, the railway is coming and saying that you have to be evicted from here. So my lord, my submission will be, let me pinpoint it. Since the municipality has given the settlement, they're taking the taxes from us, my lord. The railway could easily sit with the municipalities and tell them, see, this is the issue. We are saying it is our land, you are issuing tender and you are giving the settlement. You are saying your land, let them sort out. We became scapegoat at the sandwich in between. There's the thing, my lord. Let them sort out what is the problem in it, my lord. Deputy Commissioner is there, collector is there, municipality is there, Bongaigaon Railway is there. They can sit together and they say, no, it is our land. And the municipality says, no, you get out. Well and good, my lord. We follow that one. That's the case.
But the person in whose favor the land has been settled is keeping quiet.
That's the reason. Then why not the railway go to the municipality? Tell them, they see you are giving settlement. Why? It is our land. You tell them to get out from there. This is our land. Now they are attacked. Let them take a decision and tell us this is, you cannot sit here. You cannot do the business here, my lord. This is a very simple thing that way.
Okay,
That will be my.
who is for the other side?
I will appeal.
You'll want to make a reply.
Lordship.
Okay, after that.
Lordship.
Obligement.
Keeping in view that the fact that the petitioner stated that there are perishable items in the go down. This court directs the GMC to de-seal open the go downs of the petitioner to enable the petitioner to deliver the properties in the go downs to the recipients. Then the decision is taken by the GMC on the reply to be submitted by the petitioner. The petitioner is directed not to run the go downs which had been sealed by the GMC. The petition accordingly disposed of.
Item 27 to continue.
Yes,
My lord, please come to page number 46, my lord.
146.
Only 46.
Yes,
This is the notice issued by the railways.
Huh.
This dated 1st of March 23, my lord. To Topan Pal, like one of the vendors, my lord. Whereas I understand, I am of the opinion on the ground specified below, that you were in unauthorized occupation of the public premises mentioned in the schedule below, that you should be evicted from the said premises. Grounds, the land in question is railway land, that you are unauthorizedly occupying the land. Now railway requires the land for development work. Now therefore, in pursuance of the clause, subclause, such and such, I hereby call upon you to show cause this to Hawaii on 14th, such order and eviction should not be made. They fixed the date on 14th, my lord, but this notice, I received it after 14th, my lord. Now see the next paragraph. And in pursuance of the clause of section 4, it also call upon you to appear before me in person or through a duly authorized representative capable of answer all material questions connected with the matter, along with the evidence which you intend to produce in support of the shop on 21/3/2023. On that day, my lord, we went to the office, we wanted to submit the documents, but officially, he was not taking our documents. What documents I will show you to lordships, my lord, but he said you submitted orally. But not, anyway, my lord, this is the second part. No, lordship may kindly come to page number 91, my lord. Page 91.
yes,
Lordship.
yes,
This is Bongaigaon Municipality license form. Licensed under section 68 of Assam Municipal Act 56 and bylaw Bongaigaon Municipality. This license is hereby granted
to Rakhal Chandra Pal, my father, for carrying out trades mentioned below for the year 86-87. These licenses to force till such and such, this week, my lord, and the fees, some fees they have taken. Kindly see the next page also, my lord. Same. Next, trade license.
No, you see, maybe you have been given some license by the municipality,
Yes,
but the question is whose land is it?
that's what, because I showed to lordship, my lord, another thing, my lord. Kindly say, my lord, there's a tender in page number 40. This tender to settle the market has been issued by the Mogai
Is this person here? This Tapon Das or whatever his name is?
Yes. He's the petition number 1.
Petition number.
Yes, my lord. Now, please
So
come.
where is his, let us see his title to the land.
No, this is not my land. We are vendors. We are sitting in the market. The market belongs to municipality. Through a tender system, can be please 40. That's a tender by the municipality.
Page?
40.
Yeah.
Yes. This is the tender notice 29/1/20.
Yeah.
This was for a period April 22 to March 23.
Yeah.
This is the way it is being settled. And in the same page, the last column 3, kindly see, my lord. Clause 3. Paglastan Daily Bazaar. This is the market, please.
Okay, this bazaar is from which period to which?
This
period?
is, no, this market is being run since 1965. Since last 58 years, this market is operating. Initially, I was there, my father was there, all these petitioners, my lord, obviously. In 58 years back, my lord, they are not there. Father was running, now they are running in the market, my lord. Actually, it was given to a lessee. Lessee comes and takes tolls from us, my lord, on behalf of the municipality. That this is also I have annexed here, my lord. Now, my humble submission is, my lord, lordship has seen this, that this market is through tender system, it is now being settled by the municipality. It is giving to a lessee. We are the persons, we come to the market daily, we sit there, we have got gumti shops, lordship knows the gumti shop, temporary shade is given, and they sell certain vegetables or whatever is their items. These people are the down to the absolute poor persons. They sell their items, my lord. Now, my submission will be, municipality is settling to tender system. We are sitting there. Section 68, lordship has seen, my lord. Kindly see the Municipal Act, section 68. Just have a look on. In page 91 series, my lord, series of papers, lordship will find section 68 is there. What is section 68?
Yes.
Let me read, my lord. Lordship will got it, my lord.
Yes.
Subject to the provisions of this act and the rules made
Section
therein.
68. Section 68. reads as
Assam
a-
Municipal Act. Assam Municipal Act. This one. Assam Municipal Act 1956. Now, lordship may take my book.
Yes,
My lord, kindly see that section 68, I have marked it. It's for me actually. so
yes, yes.
It says with the limits of municipality, that I have marked it, you mark. Even from the legal point of view, if we read section 60, it says the land belongs within the limits of municipality. That means the land falls within the area of municipality.
Huh?
This section says with the limits of municipality. What does it mean? It means the land within the municipality. So the section 68 they have invoked here.
No, maybe these are municipal taxes. How does it matter? But the question is, who is the owner of the land?
That's the reason, my lord. Let the railway or the municipality who made a party. Let both the parties show to your lordships, my lord, or lordship may direct them, or they themselves really can see to the deputy commissioner or the Mongol municipality. Let them sort out whose land. If the municipality can show it to the railway board, that yes, this is your land, chapter closed. Now, in between, what is happening, my lord? I think this is the simplest solution, my lord. Let who the two higher ups sit together. And let them say whose land is there. That is very easy to find out, my lord. From the documents, cadastral map is there. Lordship. Lordship may kindly peruse page 46, Lordship, one second.
Page number
Page 46, Lordship.
46.
There's one annexure.
Page 46, Lordship.
Yes,
This is the notice, Lordship, under subsection 1, clause B to Roman 2 of section 2 of section 4, Lordship.
yes,
Under the public premises eviction of unauthorized act 1971, Lordship.
yeah.
After that, authority have issued notice under section 5, Lordship. After issuance of section 5 notice, there is a appeal provision under section 9, Lordship. And this petition.
Just a
is-
minute. Page 46 has been issued
Page 46,
under section 4.
section 4, subsection 2, subsection 1 and subsection 2 of Lordship. Public premises eviction of unauthorized occupants.
Then thereafter,
1971. Hereby Lordship petitioners are so called Lordship to represent themselves and produce the materials connected with this land, Lordship. Admittedly, this land was the railway land and railway required it for development purpose, Lordship. So railway authority issued particular notice under section 4, Lordship. After that, the documents which will be submitted by the petitioner. After examining the document, if railway authority is satisfied that this land is not belongs to the railway, then railway not issue any notice, Lordship. And if railway authority is satisfied that it is a land of the railway authority, then it will issue under section 5 notice, Lordship. After section 5 notice, there is a statutory provision there under section 9, Lordship, appeal before the concerned district judge, Lordship, as per the statutory provision. This writ petition is a premature, Lordship. So Lordship may kindly peruse for a moment, Lordship, section 4 and 5, Lordship. After section 9, Lordship. This is a notice under section 4, Lordship. After that, section 5 notice have to issued by the railway authorities. Without going to the proper procedure, railway cannot evict them, Lordship. After issuance of section 5 notice, there is a provisions for 7 days periods there to approach the district judge, Lordship, as per section 9, Lordship. This writ petition is not maintainable at this stage because of premature, Lordship. Even after issuance of section 5 notice also not Lordship.
okay, so section 40, page 46 has been issued. Now to this notice, have you filed your reply?
My lord, on 14/3, they
Page-
asked me to show the reply, but this, we have made a categorical statement. The notice you received after 14, we have received it.
No, it's okay.
Lordship
But
may give a liberty them approach the authority.
We'll
to
give
reply,
you, we'll
Lordship.
give you.
On 21/3,
uh,
on 21/3/20, the second paragraph of this page 46, kindly see my lord, second paragraph.
Yeah.
To appear on 20/3/23.
Yes,
On that day went there, my lord.
but they did not receive.
That's what I'm saying. My
Lord-
submission is, my lord, till now in
So we will fix the date.
Lordship may give a liberty, fix a date, they will approach the authority and they will submit the documents, Lordship. After that authority is satisfied, the authority will issue section 5 notice, that alternative remedy is there, Lordship. They will approach the.
No, but
district
then
judge.
you see, it is their case that they are not the owners of the land.
I am
Lord-
also time submitting here, it's not
Lordship,
my
it
land.
is not honor, not a honor of the case. If not a honor of the case, we will also execute as part of statutory provision, Lordship.
This
Because
notice
that
should go to
particular,
municipality.
that particular land is required for development purpose, Lordship. Development purpose by the railway authority, Lordship. It is not that, Lordship, that land should be idle, Lordship.
But is the municipality a party here?
Yes, that's the
Even-
reason. Municipality is a
Even
party.
municipality also cannot do this, Lordship. Means-
So let us see,
Lordship.
how did municipality, let them take a concrete stand. Because they are saying that they are not the landowners.
Lordship,
So
Lordship,
there's not denied. So no
Lordship,
point of having this.
Lordship.
Let us have a submission from the GMC,
Exactly.
whether it is their land or not.
Lordship,
Once it is not, then
it is
then the-
admittedly not their
Yes,
land.
my lord,
No,
exactly.
agree.
It is not their land,
Yes.
Lordship, so why it is not their land, Lordship may kindly peruse page 36, Lordship.
Page 36.
35 onwards, Lordship. The everything is, the picture will be clear whether that particular land belongs to the railway or belongs to the Bongaigaon municipality, Lordship. This was a letter written by the Lordship, the deed and railway officer to the Deputy Commissioner Bongaigaon in 1990.
Annexure 1, my lord, that is annexure 1.
Yes, yes,
Page 35.
Lordship.
yes.
It's not
Where it
clear
is
for me.
reflected that, Lordship, there is no provision for leasing out the land close to the third party. It is admittedly it is a railway land, Lordship. So there is no question of, Lordship, interfering by the municipality here, Lordship.
So if the municipality says that it is not their land, then what?
Yes, obviously, my lord, I cannot say anything, my lord. That's
Okay.
pure. There's the very first.
So let
reason I-
them, let them take a stand. Where is the
Yes.
municipality?
That was my first submission. If they
Yes,
say
sir.
the routes, I
Only-
will-
Okay, what I am propose here, Lordship may dispose of the writ petition with a direction to the petitioner to approach the Lordship Railway Authority. Railway Authority will consult the municipality authority and they will decide Lordship.
Okay,
Otherwise, no Lordship, it is not a matter of pending writ petition Lordship.
my
so,
lord,
so,
my-
so you approach the, just a minute. You approach, as per his proposal, you approach the authorities. And the authorities will, speak to the GMC
That's what, yes.
and,
This is
and,
BMC,
Huh?
Bongaigaon.
whatever, that
Yes.
Bongagai. And after they give a reply,
Lordship.
Yes,
then let,
yes,
let
yes.
them pass an order.
Absolutely right. my
Lordship,
lord. I
Lordship.
do no objection.
Lordship.
That's what I want actually. Let them talk to BMC.
Uh,
Then BMC will tell, oh, yes, this is not my land. This was taken on lease, or this is my land. At least one thing will come out.
Even lease was also not a part of their Lordship.
Anyway.
Lordship may give that there.
Okay, right, heard Mr. M. Nath, Leonard, Senior Counsel for the petitioners. Assisted by Mr. Pusam. The petitioners council submits that the petitioners are earning their livelihood by selling fruits, vegetables, grocery items. Pusam. While some of them have salons and shoe repairing shops in small temporary sheds made with CI sheets, in the Paglastan Daily Market under the Bongaigaon municipality in Bongaigaon. Pusam. He submits that the petitioners have been running their shops for more than 50 years while giving municipality tax. Pusam. Next para, on 16/3/2023, the NF Railway served a show cause notice dated 1/3/2023 to the petitioners under subsection 1 and clause B Roman 2 of subsection 2 of section 4 of the public premises eviction of unauthorized occupants close Act, 1971. To show cause on or before 14/3/2023 as to why an order of eviction should not be made against them. Pusam. The show cause notice also fixed 21/03/23 for personal appearance and to produce evidence in support of their case. Pusam. Next para. The petitioners council submits that the show cause notice was received by them only after 14/3/2023 and on 21/3/2023, they were not given the opportunity of being heard by the respondents. The petitioners council submits, next para, petitioners council submits that as the petitioners have been earning their livelihood in the Paglastan Daily Market under the Bongaigaon municipality, the eviction of the the attempt to evict them without clarifying as to whether the property is owned by Bongaigaon municipality is arbitrary. Next para, Mr. K. Gogoi, the learned counsel for
Lordship, respond number 1 to railways, Lordship, 1, 2, and 3, Lordship.
1, 2, and 3,
Lordship.
and 4 who will be
4, Lordship, municipal board, Lordship. It will be represented by its chairman, Lordship.
by?
By its chairman, Lordship, not by the executive officer. 4,
No, whatever it is.
Lordship, 4 will not represent, even government also not represent. 4.
Okay, respond number 1 to 3. Submits that the writ petition can be disposed of if the petitioners, if this court fixes a date, on which date the petitioners can approach the respondent number 4 with regard to the show cause notice dated
Response number 3, Lordship.
Response number 3, with regard to the show cause notice dated
1/3/23. Page 46, my lord.
Huh?
Page 46,
With regard to the show cause notice dated
1/3/23.
1/3/23.
Page
Good stuff.
46.
He also submits that the respondent number 3 shall also, in the meantime, communicate with the respondent number 4 with regard to whether the land that is in issue in show cause notice dated 1/3/2023 is claimed by the respondent number 4 as their own land. Full stop. Thereafter, thereafter, the petitioner shall be given an opportunity of hearing and a decision will be taken
As
by
per
the respondent number 3. Full stop.
Lordship.
Next para, Mr. M. Nath, learned senior counsel for the petitioner submits that he has got no objection to the proposal made by Mr. K. Gogoi, learned counsel for the respondent number 1 to 3. Full stop. Next para. In view of the consent of the parties, the petitioner, no, in view of the consent of the parties, the petitioners shall approach the respondent number 3 on
On today's Lordship, third, they may approach 5th or 6th, Lordship, because it is a
it's too short.
6,
On.
6, Lordship.
No, this celebration is going on.
Market on these things here. They're poor people, absolutely poor people.
On 10th, Lordship, 10th.
After Bihu, my lord.
After Bihu, it will be difficult, Lordship. It will
Why?
be difficult. After Bihu,
Why
Lordship,
Why?
if process is going on, Lordship, in the midway, Lordship, today I
Nothing
cannot
will
say-
happen, nothing. will.
Today I cannot say, Lordship.
What the bridge is not going to be constructed.
On 19th, on 19/4, 2023, full stop. With regard to the show cause notice dated 1/3/2023, full stop. The respondent number 3 shall also communicate with the respondent number 4 with regard to whether the respondent number 4 claim ownership of the claim any right, title or interest over the land which is used by the petitioners and which is in the name of Paglastan Daily Market.
Lordship may indicate that whether any documentary evidence regarding, otherwise claim, Lordship, they can claim any,
Full stop.
Lordship.
In the event the respondent number 4 claims any right, title or interest over the said Paglastan Daily Market, comma, the respondent number 4 shall produce documents
Lordship.
in support of their claim.
Lordship.
Full stop. The respondent number 3 shall thereafter take a decision and communicate its decision to the petitioners.
As per Lordship, 1971 Act, Lordship. Because-
Whatever, let it be as per the whatever.
Only one line, my lord. So far lordship is directed the municipality to produce the documents. Now we are saying even the reviewer doesn't have documents. Let the reviewer also show their claim on the documents. That line.
Well, railway is already claiming, Lordship. They already issued notice that
Any whatever-
this is
No,
our
where
land, Lordship.
where is your property?
This
You
is
have
our land, Lordship. Why railway will probe, Lordship?
no, just let me ask you one
Lordship.
thing. Look, please do not get agitated.
Lordship.
Do railways have land documents? Usually, do they have?
Lordship, it is a land of the railway, Lordship. It is the duty of the Lordship.
No,
to
I'm
petition.
asking you a question.
Lordship,
Please understand.
Lordship, Lordship,
We are not arguing with you.
Lordship, Lordship.
As a general cause, in general, railways have land all over India. Do they have documents of land, of their land? I don't know. Do they usually have, Mr. R. K.
Yes.
Chaudhary? They have. Full stop.
Documents along with the map.
They originally have, okay.
Cadastral map that is
Ah,
called.
that is one, okay.
Yes.
The the railways, there is point number 3, while making a decision shall also reflect the land documents in favor of the railways.
Lordship.
The writ petition, till a decision is taken by the point number 3, status quo as on today shall be maintained. The writ petition is accordingly disposed of.
This is basically in no soda. Basically in no soda, both the parties. sit
Correct,
together,
correct,
decide.
correct.
Obliged, fine. Something I don't know about there.
Yeah, please, your lordship. My senior matter is still going on in court 10 your
Item number?
that supply upgraded. Item 37, your lordship.
Huh?
Item 37, your lordship. Pardon, your lordship. I thought you were
No, no,
asking
no.
me which, in which court the matter is.
So,
going.
so this is with regard to GST.
Non-filing of
Otherwise,
GST
I have to
return
withdraw
for
it, madam.
continuously 6 months.
Huh?
For continuous of 6 months, he has not been paid. And that's why
He has not been
His
paid
court-
what?
his portal
Madam,
has been GST filing, your lordship. His
He has not
portal
paid.
has been cancelled, your lordship.
GST portal
Due
has
to
been
not
cancelled.
filing of GST.
So he
return.
can file an appeal
No,
before the
madam.
competent authority.
My lord, in the meantime, government has come up with a notification, my lord.
Huh?
In the meantime, my lord, government has come up with a notification. It was
Uh-huh.
of 31st of March, my lord. Whereby government has said, my lord, whosoever has GST been cancelled, my lord, they can apply for revocation after payment of taxes and all. I will apply under this notification, my lord. Liberty.
If that is there, you withdraw
Yes,
this with
yes,
liberty
with
to file a
liberty,
file.
with Liberty, my lord. After filing of this petition, my lord, has come up.
Okay. Mr.
R.S. Mishra.
R.S. Mishra, the learned counsel for the petitioner submits that in view of the notification number 03/2023 dash central tax dated 31/3/2023 issued by the
Hello, some director, Alok Kumar, director.
issued by the director, what director?
That much I have got, my lord, in the from the internet, my lord.
He would like to withdraw the writ petition with liberty to file a file.
Kindly, my senior name may be recorded, your lordship.
Mr.
SCKL.
SCKL, learned counsel for the GST, submits that he has got no objection to the prayer made by the petitioner's counsel. The writ petition is accordingly dismissed with liberty as paid for.
Deeply obliged. Pertaining to 18, your lordship, kindly matter may list on some another day, your lordship.
Why?
Your lordship, he is still in court number 10, matter is going on.
Okay, on the prayer made on behalf of Mr. SCKL, learned counsel for the respondents, list the matter on
On
After-
11th, your lordship.
11th. Okay,
Tuesday,
11th,
Sunday, your lordship.
11th.
All day,
Obliged.
deeply obliged.
Four.
First, my lord, I see that this is a pardon matter. Actually, I never appeared in this case, nor argued the case. How it is being pardoned, I don't know. That is, I did not argue the case.
No, you argued the case.
No, I did not appear. How I can argue? Last time I was
This
absent.
order is of 30 January 2023,
30 January.
30 January.
However, that is not the main thing. But so far I know, but
Small prayer. Preliminary objection in the matter, my lord.
now,
Chief will see
my lord,
the prayer of the case.
let me submit first, please. I am,
No,
I am
I
on
am
the
objecting.
IA. I am on the IA. I am on the IA 1294.
1294.
Your lordship will see.
No, we're disposing of the entire writ. We're not going I only. But you want me to see the I, I'll see the I.
There is no I.
Entire thing, lordship, but IA is, we have filed
There's
for
nothing
another
to IA.
reason.
Huh?
They
I
have
was for
obtained,
Getting stay.
Okay.
earlier, my lord,
Hmm.
in
Your
this
lordship will see
case,
the prayer.
Of,
No. Prayer of the case. In this.
in the main
in this
petition.
writ. At page 19. What he prays for.
17.
Under the facts and circumstances as stated above, it is most respectfully prayed that your lordship would be pleased enough to admit the petition, call for the records, issue notice upon the respondents to so called as to why the impugned provincialization order dated Iman of the respondents 7, 8, and 9 shall not be cancelled. They have been provincialized, Milord, services have been provincialized, petitioner is challenging that. But he has not applied for provincialization. He is not qualified for that also, this school. He is representing. Because they have no dice code in their favor. That is proved in the case, Milord. And when they have not applied for, how can they challenge my provincialization, Milord? Because under the act, Milord, he is not qualified. Act, 17 Act, Milord.
No, his basic case is that his school should be provincialized, not your school.
No. But on that, Milord, he said that I am fake. And he is genuine. In the prayer also, he said that he has been telling. But as I have stated, that the inquiry that was initiated at his instance has attained finality.
how it is pending, petition is pending in High Court, how it has become finality? Let him submit, my lord, I will submit later on. Because in between it is difficult to argue.
And on the last occasion, I placed that in my affidavit, Milord, your lordship wanted to see the original record because there was no date in the inquiry report. In my affidavit, I have stated, and that question, if that question is settled, Milord, that there's nothing in the case, Milord. Inquiry report I have stated, I have annexed. As annex A page 6, from page 6 in my affidavit,
Why did we call the original records? Have you brought it?
there was no date.
In whose inquiry report? No date in whose inquiry report?
My
No
lord,
date in the
all
inquiry report.
records are with me. All are false and fabricated. I will prove all this. Entire officers are purchased.
And
We
in
have
that
proof.
report, Milord, your lordship
We
will
have
see the
proof.
evidence and affidavit.
All records are with me.
Yes, my lord, inquiry report submitted by, annexed by affidavit in opposition, my lord. And there was
Page,
not
page.
Page 6
page 6.
in my affidavit.
Yes,
Page 8.
page 6, page 8, which page?
Page 8, Milord. Affidavit.
Whose affidavit?
7 and 8, Milord. Affidavit on behalf of 7 and 8.
7, 8, 9.
Yes, Milord. 7, 8, 9.
Page 6,
Page 8 here, Milord.
page 8.
Page 8, I'm sorry.
Yes,
Annex RE.
yes.
Undersigned is the, I think, joint secretary in the department. She was able to ask to hold the inquiry and Deputy Secretary, my lord, I'm sorry.
Yes, show me the record, show me the, show me that date. No, don't open, just show me the date, where, which page it is, there's such thing.
Forwarding letter, they are put there.
Huh?
That, Manoj.
My lord.
Hello. Check.
Oh, date is here. The inquiry report doesn't have a date, it is the forwarding letter which. has
Forwarding
a date.
letter.
All are fabricated, my lord, I will show.
In the minor, forwarding letter.
If it's a fabricated document, Mr. Council, can this court decide?
No, there are earlier inquiry by high ranking officer.
Mr. Council,
No, I am.
they are conflicting reports, correct? Now, according to you, the document that they are submitting are a fake document.
Fake document.
If they are fake documents,
Original documents are fake.
can that?
Thereafter they managed some persons and got the report in their favor. But thing is, they are inferior officer. Higher officer earlier inquired the matter.
There's no such thing as inferior or
Higher
higher.
officers, the verification report says that my skill is genuine and everything has been done fraudulently. And there was also criminal direction.
Yeah, government doesn't function like that. I'll just tell you. Sometimes the documents are signed by the secretary, sometimes by joint secretary, sometimes by deputy secretary, sometimes by under secretary. That it's not like district court, high court,
no, yes,
supreme court. It's
yes,
not like
that
that.
may be.
That way the government doesn't.
Now I kindly, whether your lordship is hearing the matter, I am ready for arguing the case.
I am hearing. Just tell me one thing. Is it your case that their documents are fabricated?
Original documents are fabricated, thereafter on the basis of those
Then
fabricated
I'm
documents.
sending it to civil court. Go to civil court. Decide the matter then. This court cannot decide us that they fabricated document. Whether it's fabricated or not, how can this court decide? The original records are brought before me. If you say this is fabricated,
Fabricated, I am not saying.
then I'm sending it to, you go to civil court.
Let me submit. I am not saying, kindly see page 49,
Page 49.
yes,
Yes.
of my read petition. Page 40, this is the government's order. To the deputy from P.K. Bhattacharya, Under Secretary of the Government of Assam, the Deputy Commissioner Dhubri, Assam, regarding high level inquiry against director so and so. Number seven, I am directed to enclose here the copy of the complaint petition dated so and so, received from Sultan Mahmud Mullah so and so. Is a high level inquiry against director Investigation B.O. Dhubri Chanmi. I have solved all these officers. And Penfexar, headmaster of Gunebani Madrasa Dhubri, and to request you to inquire into the matter and submit a detailed report to the government at an early stage. Now, Lordship kindly say 49. 49 is also the government's order. 49. Then kindly say next thing, my lord. Page 52. Page 52. Finding, I'm reading, I'm keeping the time, my lord. Finding of the inquiry, kindly say. Page 55, operative person, page 55, 54 kindly see. Page 54, bottom. From the above facts, it comes to light that Abul Hussain the founder headmaster in age was senior to Chanmia who claims to have been appointed as headmaster of Gunebani. This fact's been illuminated.
What do you
in
mean from the bottom? Bottom, there are 30 lines. Which bottom are you talking about?
54, 54,
54, I've got 54
yes, from the above facts,
from the above.
bottom.
Which line from the bottom?
Last lines, last 5 lines.
No, 54 doesn't say that. Oh, it's 55. It's in my petition, it's 55.
Oh, sorry, madam.
Oh, from the above facts, okay.
Then, my lord, here, from the facts above fact, it comes to light that abolition, the founder headmaster is much senior to Chanmia, who claims to have been appointed the headmaster of Gunebani Madrasa. These facts been illuminated in several inquiry reports of the education officer and officers of district administration and magistrate right number so detection. So many inquiry, lordship, kindly see. These are all the different officers' inquiry in my favor. Then kindly see next, in the context of discharge of abolition by Sri Hekmat Ali, it is worth mentioning here that abolition was appointed as the headmaster by the SMC of who is the founder and president was Tomijuddin, who continued up to 18/11/2007. After Tomijuddin, Mizanur Rahman was chairman. SMC with effect from 18/11/1107 to 7/6/2009. And Mansur Ali continued from 7/6/99 till death. Copies of SMCs are enclosed. So it is seen that Hekmat Ali was never the president of SMC of Abul Hussain School, and under such circumstances, Hekmat Ali cannot discharge Abul Hussain. They said that I was discharged from the headmaster of post of Gunebani Madrasa. After another 2 important points come to out, the written statement of Chanmia. The dice code number so-and-so was issued during the year 2008-2009. Very important matter. When once it is issued in my name, it should be issued continued, but in between they entered and managed the officers and got their names recorded. Now kindly see, then Abul Hussain was recorded as the headmaster of the Gunebani Madrasa. Chanmia was appointed on 3/9/2009 after issue of dice code. So it is clear that dice code number so-and-so is now being misused by Chanmia, manipulating the official records. And thus the school headed by Chanmia appears to be a fake one. On careful examination of all facts stated above, I am of the opinion that Gunebani Madrasa headed by abolition is original and genuine. Had it not been the fact how the dice code number so-and-so of 2008-2009 was issued, stating abolition as the headmaster of Gunebani Madrasa. If the circumstances secretary agrees, the DE may be directed to stop all financial assistance and other such assistance extended to Gunebani Madrasa headed by Chanmia and take all corrective measures for taking up the school headed by abolition as genuine, taking further steps for extending assistance to school as per government law. This is inquiry was conducted by house to house, asking by the Joint Secretary, the Government of Assam, Secondary Education Department. Now, the other officers, this cluster research officer, they have made this inquiry. Then lordship kindly see page 61, my lord, kindly see annexure 21. If this be the state of affairs, how the genuine persons will live in this world, my lord? Here kindly see page 61. From R.C. Jain IS, Secretary of Government of Assam, to the Director of Elementary Education Assam, action against Gunebani Madrasa headed by Chanmia as headmaster under Dhubri district. I am directed to say that the dispute of Gunebani Madrasa headed by Sri Chanmia and Sri Abul Hussain was inquired into by Sri M.H. Lashkar, ACS, Joint Secretary of the Government of Assam, Secretary Education Department, Dispur now. Inquiry report has been submitted to the Director Department on 15/5/2014. Copy of the inquiry report is enclosed. From the report, it appears that Gunebani Madrasa headed by Sri Chanmia is a fake one. You are therefore requested to take necessary action accordingly as follows. No Any government grant including financial incentive should be provided to Gunapani Himmatha headed by Chanmia henceforth. Steps to be taken to recover if any grant already provided to the said school. Further, school should not be processed for provincialization. On the other hand, all the facility as per existing norms of government, financial incentives, MDM, FTB, etc. are to be provided to Gunapani Himmatha headed by Abul Hussain. So, my lord, these are continuous. Everybody is saying my school is junior, all papers are with me. Now, the dice note in the year 2008-9 was in my name. Thereafter, they purchased some officers and got his name. How original thing is in my name, then how it should be transferred to him? And he was not appointed at that time. In the year 2008, he was not appointed even. For doing misdeeds, he was ousted. And he then started another school. And we have shifted the school with permission of the government. We have all documents here. I have also annexed here. So, my lord, all these inquiries, against all these inquiries, government officers' inquiries, they have been provincialized. So it is a serious matter. It is not a light matter. They have menaced everybody. Let them produce the original record. If he is the headmaster, original records should be with him, but he has no record at all. All the original records are with me.
All original records are with you,
Yes.
not with the government.
Government asked me, could I have produced?
He has been referring to letters of 2014.
Yes, I have.
Yes,
I have
yes,
also.
He has
received-
himself
I have also
annexed
received
the
from
order
the
passed
government.
by last
I have
Wednesday.
also received from the government that I have produced the
Justice
document.
Durbe,
I have
your lordship will
received.
find
So,
by
my
which
lord,
that
it is-
inquiry report was cancelled and asked to get a press report, press inquiry. Your lordship will find that at
Yes,
5 days order at page
so those tests
74,
I will
75.
come. That was- I
Then
will come.
thereafter, there was the inquiry by the chief secretary. Yes, commissioner.
So the latest inquiry report is the inquiry report submitted by the deputy
He
secretary.
himself have annexed that million. Your lordship will be 78 million, page 78 of that petition. This officer was appointed. He has himself said it. Lordship has
Now,
seen, order dated
Yes, page 78.
18 November 2020. In compliance
Yes.
with the Honorable High Court's order dated Imaniman, Onjul Onuja Bhuya, ACS Deputy Secretary, Assam is hereby appointed as inquiry officer.
Mr.
Our report
28.
is there before your lordships. No. Onuja Bhuya, Secretary, Government of Assam Inquiry Department is requested to call inquiry into the matter and submit report within 3 months to the Commissioner and Secretary, Elementary Department. And on the basis of this, Lord, she has submitted the report. That is before your lordships. Lord. Along with the original.
Original? Original, later on some inquiries have been made, those are things, but original documents I have submitted before the authority, he has submitted nothing. But yet in his favor, the order has been passed. That is why I am before your lordship. He could produce no relevant document. Only on the basis of some fake document, he started his life and finally got the order. That is why I am before your lordship that on inquiry report, copy of inquiry report has not also been furnished to us till today.
Okay. That's all?
No. And in my affidavit, and of the inquiry report, Milan, I have given there, your lordship will find the statements given by the persons, including petitioner also.
Well, one thing I will show your lordship. One order that was actually I don't know whether it was my
At
fault.
page 9, your lordship will find petitioner's statement, then thereafter hearing of Abul Hussain, then hearing of the respondent number 7.
Yes, what is Mr. Chalia, what is your case? Your case is that the latest inquiry report should be followed. What is your submission?
My submission is, Milord, that was the final inquiry that was initiated at his prayer, Milord. It has been published, and on the basis of that, Milord, he was
In compliance with the order of the High Court and the last order,
Yes. my lord.
this,
Yes,
this deputy
immediate
secretary has,
attendance.
made the inquiry
Right.
and that now will, rule the rules.
Yes,
That is your case.
that is the case.
Yes, my lord. Kindly see, my lord.
And, your case is that all this is the original
okay.
inquiry made by the joint secretary, that could not have been changed.
That could have.
That was correct.
And another thing, High Court has also set aside their order. Kindly see, that's why I'm drawing. Kindly see, my lord, page 20, page 19 of IA. This was the order against me. That based on abolition, page 19, last order, kindly see, page 20, bottom, decision. Considering
Yes.
Considering the above facts and materials in hand, the school Gunebani Madrasa in which Mohammad Chanway is functioning as headmaster, situated at Gunebani village, is found to be genuine and eligible for financial assistance. So his school was held as to be a genuine. Now, against this, I approached the Honorable High Court and High Court passed order, kindly see. That may be seen, my lord, page, operative portion, page 26, bottom, para 14. Page 26.
Yes, so accordingly, respondent number one is direct to reconsider the matter and take a fresh
That was
decision.
set aside. That was set aside.
No, it has said to take a fresh decision.
No, that was set. Kindly see page 26,
Yes, okay,
bottom
26.
para 14. From the
26.
above, this court is of the opinion that the impugned order dated 6/12/17, that
Correct,
which you
correct.
yourself,
Ah,
issued by the respondent suffers from material infirmity.
Correct.
The same being not properly sustained by materials on record cannot
Correct.
be held to be valid, and accordingly, the impugned order dated 6/12/17 is set aside.
Yes, now read the next.
Accordingly, respondent is directed to reconsider the matter and take a.
To reconsider the matter. Reconsider the matter doesn't mean that you have to consider this way only. Reconsider impartially, fairly. So he can go this
Yes.
way or this way.
Yes, that is true. Now, thing is this, on the basis of what, my lord, finding should not be a fanciful finding. It must be supported with documents. Now, what documents I have submitted, that is misread, misinterpreted in the finding, and that what document they have filed, so my submission is that if a finding is given, that must be reasonable. It is the function of the government. State cannot act malafidely. So state officer should form his opinion on the basis of the documents submitted by the parties. Now I have submitted all the relevant documents in the starting of the school till today. And he has submitted some fake documents which have been already proved that these are fake. On the basis of those fake documents, step by step it became genuine. So my lord, they have, this finding have not gone into root of the cause. And moreover, the copy of inquiry is not till today furnished to me. So I am also not in a position to.
It is there in your, in the affidavit of the respondent, 789.
Affidavit is given, but when.
Then
I
it is
su-
furnished to you, it is there in your affidavit. Affidavit of 789 is with you.
No, it is submitted, but I wanted to know what documents I have submitted before them. That is not the enclosed hearing.
I know.
Ah.
That will,
So that is my submission is this, the finding or creating an opinion must be on the basis of foundations. They have no foundation.
okay, right. Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. G.P. Chaliha, learned senior counsel for the respondents number
7, 8, and 9.
7, 8, and 9. Assisted by Ms. M. Roy. Also heard Mr. G. Pegu for the state respondent. Hearing concluded, judgment reserved.
My lord, this is related to my lord.
Related to murder.
No, my lord. Constitution of Subdivisional SC Board, my lord. At Rongia, my lord. And the SC Board has been found, my lord, in the year 2022, my lord. And not as per the guidelines, my lord. That is, my lord,
Yes, what is to be done here?
My lord, for me, there is a technical problem, my lord. My lord, what happened? There is a bifurcation in this WPT and BC department now. A new department has been created, social justice and empowerment, and this OBC, from WPT BC, OBC and SC has been, my lord, bifurcated to the new building. I have informed madam. So she will have to implement social justice and empowerment. I
My
won't be dealing with this.
My lord, this is a different thing altogether, my lord.
My lord,
Because our board has been formed by the principal secretary WPT, my lord. And here, my lord, the new,
Look, look,
my lord, this is a wrong board, my lord, which is unconstitutional board, my lord. If this stays, my lord, then even the new department will not look at the things, my lord. Grievances of the petitioners, my lord. Because they have not issued, my lord, this board. The board has been formed by the principal secretary, my lord. By the department of, my lord, by the WPT and BC department, my lord. And that is at page, my lord, 52.
why don't you file an affidavit then? You file an affidavit in opposition.
The learned friend had taken times, my lord, so much of time, and this will be infectious, my lord, after some time. If
My
it
lord,
gets delayed, my.
I cannot file even affidavit because I don't hold the brief for this WPTBC as of today doesn't exist, this department. There is a bifurcation. Two department has been created out of it. There are two directors.
WPT, so this department is not there anymore.
No more, my lord. So my lord, this
This is there,
Rangia
this is
division.
This is the, my lord, WhatsApp message, my lord.
You just write an, madam, he is saying this
Yes.
department is not in existence, then what to do?
This
So-
is in existence, my
It
lord. The
is-
department has not been made.
It has
my
been
lord.
bifurcated, you mean?
Bifurcated, my lord, WPTBC.
So you cannot get the full instruction.
So I gave
Why can't you get the full instruction?
Yeah.
Yeah, are you engaged departmentally? Department wise?
department wise, my lord. My lord, there is a standing council, my lord, for this social justice and empowerment.
Okay.
RM Das. He is, my lord, so this SC issues he handles. So I have given her the phone number even, my lord. So, my lord, let them bring it on record, my lord, whatever they have, because I'm not authorized, my lord.
So
That is my
yes,
problem.
Lordship, I am appearing on behalf of Mr. Aram Das. Lordship, our name is not shown in the positive. And
Because, my lord, they are not even made parties, my lord.
they are not party.
They are
How
not
can?
party.
You are not a party.
it can-
My lord, this is only
Anyway, we'll fix another date. I don't know. Okay.
my lord, till then, my lord, can it be state, my lord, the new board? Because, my lord, they illegally made, my lord. They
Right.
have not followed the guidelines, my
Right,
lord.
list this matter again on 19-4.
Meanwhile, my lord,
19-4, which?
till then, my lord, can it be?
19-4, madam, next.
Applies, my lord. Now, can it be a bit, sorry, my lord, 19-4, I might not be here, my lord, I'll be out of.
20, 21,
21,
21.
obliged.
Yes.
May it please your lawsuit.
What do you want out here?
My lord, virtually it's a covered case, my lord. Annexure 3, a judgment of reasonable court, my lord. My lord, what if in a little background,
No, what do you want? You want your land to be demarcated or what?
Yes.
Are you landowners?
Yes, sir. With the landowners, because in the last settlement operation, it could not be conducted as difficulty was felt by the survey department. So similarly situated person approached your losses earlier.
No, if you see, if you're landowners and you want demarcation of your land, then why don't you file applications before the circle officer under the Assam Right to Public Services Act?
My lord, not actually demarcation, even the third survey operation has not been conducted in our area. My lord,
Are you a landowner?
yes,
I-
we have
you-
been possessing the lands for long.
You have been
years.
possessing the land.
My lord, kindly see the page 29, the report of the settlement officer.
Yes, what is to be done, madam?
Similar order has been annexed,
Huh?
case 48.
Page 14.
Page 48, my lord, operative
40.
part. Of the
Yeah.
last judgment.
Page 49, Lordship, last paragraph.
Okay.
Therefore, without commenting on the merit of the claims and counterclaims of the parties in the writ petition, I dispose of the writ petition with a direction upon to the respondents to expedite the process of preparation of the trace map, Vandike map, and also carry out survey and verification of the land involved in the present proceedings as noticed herein above. The proper verification, after proper verification, Lordship, field verification or after survey.
You see, but then those cases are different. In this case, they are patadars. And they are, they are owners of the properties on the basis of registered sale deeds. How is that? How it's different? Out here, they're not patadars. They're not even owners of the properties on the basis of sale deed. They are in possession. That's all. So how is it? It's a different.
No, my lord, some lands are the registered, say, we have purchased patadars, not all are our.
Where? Who are patadars? You show me who are patadars.
The patadars, okay.
You first show me your right to the property. You don't have any right to the property. Where's the question of allowing your prayer?
My lord, we are in the similar footings of the last petitioner. I have drawn your lordship attention to the judgment. Page 48, my land representative.
You see, page 48, let me read for you. Since you see, just let me read.
Yes.
It is the case of the petitioner that these plots of land have been occupied by them as the legal heirs of the patadar and or based on registered deal of sale.
In our case also, there are registered sale of this, but my lord, we have not annexed. it
Annex,
because
Can you
we
please
wanted
annex?
Similar,
You please annex. You please
Similar-
annex.
similar order will cover in this
And in
line.
the
my lord.
meantime, we'll obtain instruction. Lordship.
Yes. Mr. R.M. Raj Barbuyan, learned counsel for the petitioners, submits that some of the petitioners are patadars and some of the petitioners are owners of the land on the basis of registered sale deeds. So stop. He submits that he will produce the said documents on the next date. So stop. In the meantime, Ms. G. Hazarika, learned counsel for the state respondents shall fine.
That's one number 1 and 2. Lordship.
first point number 1 and 2, and who else?
And for respondent number 3, 4, 5, and 6.
Name. And Mr. R. Tarumdar, for respondents number 3 to 6, shall file an affidavit in the position.
Okay.
All right.
Yes,
In this case, my lord, let the matter be listed after the application. I will find my reply, my lord.
Lordship, in my submission, lordship, there's no case as on date.
No, in fact, there was a clear, my lord, clear violation of the order.
The warrant which was issued by me was issued when I was not informed about the course order. As soon as I got the course order, I recalled it. Therefore,
then what remains?
No, my lord, in fact,
Let us see the court order,
Dr. will file, my lord, at page 11.
page 11. Mr. R. Day, then you should notice.
Second last paragraph.
Pursuant to Bikaji case number so, Bakijai case number so.
Yes.
So this was order dated 31/2019. Then where is the order?
The next page, your lordship will see, that was the, my lord, page 12. Immediately on this next day, my lord, we served a copy. Now, what has happened, my lord, thereafter, in spite of this, my lord, he issued non-bailable warrant of arrest. And in fact, my lord, thereafter, we received a call from the.
Issued on 17/12. 17/2.
Now, lordship will see, we received a, my lord, phone call from the Nunmati police.
Okay, you file your reply.
Lordship.
Mr. R. D. Learned counsel for the petitioners is granted 3 weeks' time to file affidavit reply. This is the matter.
As per telephonic instruction, lordship, the petitioner has got relief.
Release. Mr.
Take only.
K. Kalita, learned counsel for the petitioner, submits that the contempt petition can be closed as the petitioner has been given the relief sought for. Stop. Accordingly, the contempt petition stands closed. Finish. Finish. Mr. Gogoi, one thing. This, item one, where warrant of arrest had been issued. And because that certificate officer had issued the warrant of arrest and issued the notice. Now that certificate will still stand. So what can he challenge? He cannot challenge anything. He'll have to go in appeal or something. There is appeal provision. Where?
Restrictive provision is there, lordship, as per the Bengal Public Recovery Act.
Just show me. Bengal,
You can approach the deputy commissioner probably, lordship.
just show me the provision.
Lordship.
Where is that at?
Lordship, probably section 34, lordship. Section 34, reference to civil court, lordship.
Section 34.
Section 34, lordship. Section 34 says that lordship suit in civil court to have certificate cancelled or modified, lordship. The certificate debtor may at any time within 6 months from the service upon him of the notice required by section 7. That is also section 7, lordship. If he files in accordance with section 9 a petition denying liability from the date of the determination of the petition, lordship. That is provision there, lordship. Under section 34, he can approach the lordship civil justice.
So I think that has.
Lordship, it is the remedy, lordship.